Okay, I think we can get started now. We have Assemblyman Perry, Assemblyman Lenthal, and I'm John DeFrancisco from the Senate. The purpose of this hearing is to discuss issues surrounding the prosecutorial conduct bill that both Mr. Perry and myself have in the respective houses. And what we try to do is get a balance of people that may have different viewpoints on this to give their opinion, and then thereafter we will be able to have some interaction, some questions and answers, and the like. There's 12 people that have been asked to testify, actually more, some canceled, and some were added. The reason for the setup as it is right now, I thought, and we all thought, that it'd be good to have a balance of opinions on the first round, rather than having one side or the other on this issue, monopolizing it until people get tired. So that's where we were. So if the first group, if we go left or right, just identify yourselves, and then we can start the hearing.
Good morning. Albany County District Attorney David Soares.
Good morning. Oneida County District Attorney Scott McNamara.
Bennett Gershman, Professor of Law, Pace University.
Marvin E. Schechter, Criminal Defense Attorney representing the New York State Association of Criminal Defense Lawyers.
Robert Temekjian, the Administrator and Counsel to the New York State Commission on Judicial Conduct.
David McCallum, exoneree.
Keon Daniel Katibi, exoneree.
All right, now, what I'd like to just mention, if we could try to limit our initial remarks, hopefully to 6 or 7 minutes, just to give your general impression, and we could start the discussion thereafter, and then we'll rotate so that everybody that was asked to be here can put their 2 cents in and be subject to questions. That's basically what's going to happen. It's being live streamed, I guess. So you're all dressed nicely and you look good, so that'll work. So there may be a movie career in the future for all of you. But in any event, if either Assemblyman Lenthal or Assemblyman Perry would like to make some opening remarks, we'll go from there.
Well, I don't want to preempt the sponsors of the bill. I guess I'm here to be a moderator between the Assemblyman and the Senator, as well as you. I'm the chairman of the Assembly Codes Committee. So I'll ask Assemblyman Perry, since it's his bill, to make some opening remarks if he wants to.
Thank you, Mr. Lenthal, my colleague. Bill is not my bill. We both, Senator DeFrancisco and myself,
I apologize. I meant to say that if I didn't.
That was not a complaint or indication that I thought that way. However, Senator DeFrancisco and myself, I am pretty sure, very strongly believe in the need for checks and balances on one part of our government and our criminal justice system, our legal justice system, where the holder of the office is endued, authorized with tremendous power that has immeasurable impact on the lives of anyone who has the unfortunate opportunity or cause to appear before the justice system seeking justice. In every other part of the government, the presidency has significant checks and balance. Our judges, even themselves, has checks and balances. There exists for judges who have tremendous power a commission on judicial conduct, and so. But prosecutors who have a unique power to make final decisions in cases before the case even go to the judge, can determine, and in the community that I represent, a lot of where thousands and thousands of African American youngsters appear before judges making plea deals, many offered without a prima facie case having been even proved to exist. It's just an example of the power of the prosecutor. So we have put together what we think is a recommendation. We want to enact that into law that would provide a source of check and balance where anyone who has a problem, a concern that the office may have been abused or the owner of the office may have indulged in misconduct of any nature, not intended or otherwise, but certainly contrary to what we think to be a true justice approach to justice, will be able to make a complaint and have the complaint properly addressed. So we are thankful that you are joining us today, and hopefully we'll hear from you. Just finally, I'd just like to mention that we were very careful to not, or we have taken, made the effort to not have this described as a commission on misconduct, but all sorts of conduct by the prosecutor. You will complain, it doesn't necessarily have to be a complaint that is a case of misconducting themselves, but also complaints that impact on the office. Thank you.
Thank you, Nick. So just before we begin, I want to make some short remarks.
It's too late. We gave you the opportunity already.
I'll take it anyway.
Okay.
So the point of our discussion today is, well, let me say this. I began my tenure in the state legislature in the state assembly in 1973, and I have seen the power of prosecutor's office grow enormously in that period of time. And partially because of legislation that we have passed in Albany. And power is good, but we also know that power can corrupt. And so, you know, we're in the midst now of a whole host of pieces of legislation that we want to adopt in order to prevent corruption from public officials, as all of you know and have read about in the newspapers. And so it's not because we don't want to leave anybody out that we're having this hearing or discussion today. But it is important when, as Mr. Perry said, we understand that prosecutors now have, as I've suggested, an enormous amount of discretion regarding both the investigation and prosecution of crimes. And it's in the public's interest to promote acceptable standards of conduct, like we did for judges when we saw that they had tremendous power that they may have been using in an unsavory way. And so, not to suggest anything, but just to bring this topic to the forefront in an intelligent discussion. That's why we've chosen the roundtable model to do it. And I agree with Senator DeFrancisco and Assemblyman Perry that this is the kind of balance that we wanted to achieve in promoting this discussion. So let us begin.
Thank you. The bill was really modeled after the Commission on Judicial Conduct that's been in effect for many, 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 many years. So what I'd like to do is the first call on Robert Tembekshian, the Commissioner, the head of the Commission on Judicial Conduct, and just give a brief overview of what your operation is like and what the results have been in your point of view. By the way, we also have someone here in the second row, which doesn't mean anything about your capabilities. It just means there wasn't enough chairs. Stephen Downs was the past chief attorney for the same organization, and he can give some historical perspective concerning this commission. Mr. Tembekshian.
Thank you, Senator. And I'm happy to be here and talk a little bit about the structure and experience of the Judicial Conduct Commission over the past 4 decades. Before there was a Judicial Conduct Commission, the responsibility for disciplining judges in New York State was spread out among various levels of the court system. The appellate divisions each had responsibility for lower court judges. There was a special court on the judiciary which had responsibility for disciplining judges of the more senior or superior courts. But in the 25 years before the Commission's creation, the Court on the Judiciary, which was an ad hoc court, was convened only 5 times by the Chief Judge, which was the structure at the time. And there was, among the public and certainly in the legislature, a dissatisfaction with the ineffectiveness of the system that was then in place for enforcing rules of ethics and ethical conduct on the judiciary. So by virtue of a constitutional amendment, what was originally created by the legislature as a temporary commission was made permanent, and then our operating procedures were filled out in the judiciary law. And it's that statute, Article 2A of the judiciary law, on which this legislation, sponsored by Senator DeFrancisco and Assemblyman Perry, is modeled. At the outset, I must say that there was widespread consternation among the judiciary about the potential cloud that the creation of a Judicial Conduct Commission might cast over the independence of the judiciary. And it's a subject over which we have been especially sensitive in the 40 years that we have been in operation. And there are many ways, and I think that our results over those years demonstrate that not only has the Commission not undermined the independence of the judiciary, but in many significant respects, we have actually served to promote the independence of the judiciary. And let me say a little bit about how we've done that and how our procedures have enabled us to do that. We have a staff of 45 in 3 offices throughout New York State. We receive now roughly 2,000 complaints a year. And given that there are approximately 3,300 judges and justices throughout the court system, that's a significant number. But the number of public disciplines every year is in the range of 15 to 20. And the number of confidential cautionary letters, which are not discipline, but constitute suggestions and recommendations to a judge, number in the area of about 30 to 35 a year. We screen every complaint that comes in. The staff will clarify it where necessary. We will summarize it. We'll do an analysis of the provisions of law or rules that have alleged to be violated, and we'll present every one of those complaints, even the ones that are not about judges, to the entire commission, which will determine whether or not to conduct an investigation. Out of the 2,000 or so complaints that we receive a year, about 450 are the subject of an initial review and inquiry or a clarification, which does not involve communicating with the judge. We might look at a transcript, we might look at court records to try to get some sense of what the essence or gravamen of the complaint is, so that the commission can make an informed decision on whether or not to investigate. And out of those 2,000 or so complaints a year, we investigate somewhere in the range of about 150, and I think our high was about 225 one year. And out of those, as I said, only 15 to 20 are going to end up in public discipline. So in many respects, we absorb a lot of the public hostility toward the judiciary, much of which is the result of complainants who are unhappy with the results of their litigation. They lost, they don't want to accept it on the merits, so they make a complaint to us. And as we're required by statute, we explain to every complainant when we dismiss a complaint what the basis of that disposition is. So we are in a position to not only absorb a lot of the criticism that might otherwise be directed at judges, but we explain to the complaining public why it is that our system and the administration of justice requires that their complaints not result in any disciplinary action against the judge who just called it as he or she saw it. You'd be surprised at the number of times in a year we'll actually hear from complainants after they've heard from us, expressing appreciation for having taken the time, examine their inquiry, explain to them what our procedures are and why their complaint was not going to result in discipline. And they may still not be happy that they lost, but they appreciate or understand that it's not the system or the judiciary that's at fault. We've had, in 40 years, 805 public disciplines, and that includes 60 cases where we stipulated with the judge that the judge would leave the bench and never return to office again. Clearly, stipulations of resignation or removals are reserved for the most egregious conduct. Public reprimand, either a mild admonition or a more severe censure, for intermediate misconduct. 92 or so of those cases have been appealed directly to the Court of Appeals, which is, as our Constitution and our statute direct, at the option of the disciplined judge. Never in all of those years has there ever been a finding by the Court of Appeals or by the courts in Article 78 proceedings that have been brought against us by judges that the Commission improperly intruded on the discretionary, call them as they see them, function of the judiciary. There has never been a finding by any court that the Commission has impeded the independence of the judiciary by examining complaints of ethical misconduct that have been made against judges. In our early years, we were the subject of approximately 100 lawsuits brought by individual judges or judicial associations, challenging our procedures, challenging the enforceability of our subpoenas, challenging the scope of our investigations. But because our rules and procedures, which were promulgated, published, amended from time to time, sometimes at the suggestion of judicial associations and bar associations, are based on a due process model. No judge can be disciplined in New York without due process. And due process requires that the judge have an opportunity to respond to any complaint or investigation before the Commission would vote formal charges against the judge. And clearly, once formal charges are voted, the proceedings go to a referee, the rules of evidence apply, there is due process of law, and then after the hearing is over, the judge has an opportunity to make a presentation to the entire Commission. These are very sophisticated, time-tested due process procedures that ensure that we give to the judiciary the same rights and appearances of rights that they're obliged to offer to the litigating public.
Thank you. I'm going to take the liberty of just going down the road. Maybe we can have everybody in this table speak, and then maybe if you got questions later, that way we get a couple of rounds here. Phil Boyle, the senator, is here, very interested in this issue as well. Next, I'd like to call on Marvin Schechter, New York State Association of Criminal Defense Lawyers.
Good morning, and thank you, Senator, for the opportunity to represent the New York State Association of Criminal Defense Lawyers on this important issue. The association completely supports the bipartisan effort to pass this legislation. We have seen firsthand the deleterious effects of unbridled prosecutorial misconduct, unethical behavior, and in some instances, illegal activities. Perhaps the best way to understand what it is that the prosecutors are doing and have continued to do, and at this point have extended, is to understand some of the cases that have appeared before courts where decisions have already been made that unethical conduct has taken place. The initial presentation I have will give me enough time to give you all the cases, but I'll give you the thumbnail and then go into it in detail. Between 2004 and 2013, one assistant district attorney in upstate New York, Jeffrey L. Taylor, wreaked havoc upon the system. In 4 stated cases before the courts, the cases were reversed in 3, and 1, the courts did not reverse, all based on Mr. Taylor's unethical conduct, describing witnesses as liars, calling defendants sexual predators, asking illegal questions such as, do you have an arrest record? And it was much, much worse. What was interesting about the Taylor case is that by 2012, the courts began to understand who Mr. Taylor was. And 2012, in a case called People v. Huntsman, which the court did not reverse, the court stepped aside and said, although we're not reversing, we take a moment to caution Mr. Taylor, who we have repeatedly admonished not to conduct himself in this fashion. And that's exactly what they did. Did that deter Mr. Taylor? Did it deter his supervisors, his office? No, he continued to practice law, and in fact, he continues to work in the DA's office in upstate New York. Astoundingly, if the appellate division finds that they have to admonish an attorney repeatedly, one would have thought that the disciplinary system would have kicked in. And to that end, the New York State Association of Criminal Defense Lawyers made a complaint. Rare for the association, which has a structure for doing that, and which I think has rarely been used along the lines of what Mr. Tembekian was just talking about. 2 letters were sent to the Grievance Committee of the 7th Judicial District. Both letters were rebuffed. The complaint filed by the association was not even considered. And that should underscore for the 4 of you how dead, how moribund the disciplinary system has become. Today, one of the things that we should explore, and I hope we'll get some questions on this, is how the lack of accountability has totally contributed to this excessive misuse of power. There were 2 structures for accountability of prosecutors.
Mr. Schechter, can I interrupt you for
Sure.
just a second? I think it's necessary, I guess, for some of us who may not be aware of it, including me, as to what the disciplinary proceeding for a district attorney is and how that differs from what was available to a judge prior to the Commission on Judicial Conduct. And is the procedure, as I think it is in my mind, the same kind of disciplinary proceedings that's involved for any defense attorney that we're talking about for a district attorney?
Would you like me to go into it now?
Yes, please.
As we understand the disciplinary procedure from what we've been able to learn, because a lot of it is shrouded in secrecy, a complaint is made by a bar association, by an attorney. In fact, it can be made by any member of the bar, including non-members of the bar. The public can make a complaint. The complaint goes into the disciplinary committee. It is then evaluated for its efficacy and veracity. Now, initially, a lot of these complaints never get past that stage. So we don't know, because there's nothing published that indicates what happens and how that procedure works, that initial screening process, if you will. But assuming it gets past that stage, it goes within the disciplinary committee to members of the disciplinary committee. And here lies the rub. In some of the disciplinary committees, in some of the departments, the complaint goes to panels of 2 or 3 members of the disciplinary committee. But in others, the complaint, particularly when it involves a district attorney, is shunted aside. Let me give you an example of that. In Manhattan, in the first department, the disciplinary complaint goes to an executive committee, culled out from the total membership of the disciplinary committee. That committee then decides unto itself whether or not the complaint has any validity. If it gets that far, and it gets into that kind of analysis, the district attorney is permitted to respond to the complaint, and in fact, the district attorney comes in often to plead their case. Line district attorneys are often accompanied by executive assistants, and these are not just normal supervisors, they're usually much higher supervisors, usually people very close to the district attorney. That was the case, for example, for many years in the Bronx, where one of the executive assistants, one of the top authorities, was the liaison from the district attorney's office to the disciplinary committee. And that person then explains to the disciplinary committee what the complaint is. Many members of the disciplinary committee are not criminal defense lawyers. They are not former prosecutors. Large numbers of them are civil people. These disciplinary committees are the result of appointments by the judiciary. Now, when the district attorney goes in and pleads their case, the complainant, the person who made the complaint, for example, myself, is not informed of anything going on in the committee. In fact, not only are you not informed, but whatever the final result is of that procedure in closed door session is never reported out to the complainant. And for years and years and years, and this is my 43rd year in the practice of law, we have no idea how these complaints are being processed. But rather than continue it, if you want to see how bad the system has become with respect to disciplinary committees, you should read an article in the Fordham Law Review that was published by a defense attorney named Joel Rudin. It is dated November 2011, and if you wish, Assemblyman Lentol and Senator DeFrancisco, the association will make it available to you under separate cover. This is an extraordinary article because it explores the very issue that you just talked about. So that's how that works. So without taking up more time of my fellow panelists before you, I will go into other cases, 2 of which I brought to you today, which have never been reported publicly, including one that has recently happened in which a district attorney's office sought to isolate a defense attorney who made a legitimate motion on behalf of her client by exacting economic retribution against this individual attorney. Case is still pending. We're waiting to hear what happens, but it's an extraordinary misuse of the prosecutorial power outside the courtroom. I want to bring to your attention 2 other cases today out of the Bronx. Remember, as we sit here today, that the National Registration of Exonerations...
Excuse me a minute.
Yes.
I really appreciate the detail that you're giving. We got 12 people in
I'll
questions.
finish up.
So you got to, as far as the cases, if you summarize them quickly, so everybody gets the opportunity.
I'll be happy to sum them up as follows. Some of the worst cases that we've seen in the last several years are out of the Bronx. The Bronx, as you know, from the National Registration of Exonerations, is either the 4th or 5th worst county in the United States of America for wrongful conviction. This has been going on in the Bronx way back into the 80s. Mr. Rudin, in his Fordham Law Review article, traces the history of prosecutorial misconduct in that borough in detail. Thank you very much.
To be fair, the district attorney is no longer the district attorney under which many of those complaints occurred. Is that correct?
The complaints that were the subject of Mr. Rudin's article and his analysis occurred under District Attorney Robert Johnson.
Thank you.
Thank you. I'd like to now ask the district attorney from Oneida County, Scott McNary.
McNamara.
McNamara, I got an extra Y here. Okay, thank you.
Thank you, Senator. As you said, my name is Scott McNamara. I'm the District Attorney of Oneida County. I'm also the President-elect of the New York State District Attorneys Association. And I am joined here today by the District Attorney for Bronx County, Darcel Clark, who is a former appellate division judge. I'm also joined with the District Attorney of this county, Albany County, David Soares. A few things that I just would like to mention in response to some things that have been said is, first of all, the presumption that there is no checks and balances on us is incorrect. We do have checks and balances. As a matter of fact, we have numerous checks and balances on prosecutors. First of all, the judges, starting right off with the trial court judge. They have the ability to suppress all of our evidence. They have the ability to discipline us. They have the ability, if it's an assistant, to contact the district attorney and ask that that person be punished, as the case might be. We also have the attorney grievance procedure. I would disagree with my good friend, Mr. Schechter, who we also serve on a commission together. The grievance commission does work, and I know that personally. Fortunately, I've never had a grievance against me that's been founded, but I have had people that work for me have that done. Now, the problem is that information is not made public, and there's reasons for that, and maybe that's something that could be fixed. Maybe if you knew what happens and that things that people do are addressed, maybe there wouldn't be this presumption that we have this totally unchecked system going on and that we are not held accountable for things that we do. In addition, judges can file grievances against us, public can, and just to explain the procedure, having been through it, and I'll tell you, the last grievance that was filed against me was filed against me because I would refuse to prosecute somebody. And I only say that to you because my main problem with the commission you're trying to create is this. This commission is going to have a chilling effect upon prosecutors doing their job. The most difficult thing that we do that causes people to really have problems with us and come after us is when we refuse to prosecute something when they feel that they're wrong. And the #1 tool in the criminal justice system to prevent wrongful convictions is prosecutorial discretion. Because when we look at a case and we say, I don't think the person's guilty, I don't think the evidence supports prosecuting this person, and then you end up with a grievance like the last one I had because I wouldn't do that. So then what's going to happen is we're going to spend the vast majority of our time defending every judgment we make, trying to make the system better. And do you want us spending all that time defending every judgment call we make? Or do you want us doing things like DA Soares is doing, that I'm doing in our county, doing second chance programs, doing conviction integrity units, trying to make better relationships with the community that we most affect? I mean, those are the things prosecutors should be concentrating on, not coming before a commission defending every judgment call we make because somebody disagrees with us. And when you do get a grievance filed against you, we do have rights. We have the rights like anybody else. We have the right to defend ourselves and to have an attorney present. That's not wrong, that's fair. We have the right to due process. We should have the right to know what the burden of proof against us is. And you know what? Just like the people that we deal with every day, people are falsely accused. And people have the right to defend themselves. And that concerns me when my good friend Marvin says, that we show up with attorneys. Well, I would hope we do. Just like when we put a case in the grand jury and the suspect comes to testify, they should have an attorney present with them. That's not only a right, I think it's a necessity when you're dealing with somebody's livelihood. So, I share with you that, but the procedure is someone files a complaint, we do have the right to respond to it. You have the right to respond, and then you tell them what you did, and then they decide at that point whether or not they want to do a further investigation. And if they do a further investigation, then they call you in front of them, you will have to testify. So there is a procedure in place, and I can assure you, and what I would ask, and we've talked about this before, Senator, I would ask that we do something to try to determine how many people are disciplined. Because I don't think any of us are proud, but people make mistakes regardless of what job they're in. Prosecutors make mistakes. And there's a big difference between a mistake and misconduct. And that's something that needs to be looked at. And, you know, are we going to be answering to every mistake we make versus the egregious things that, you know, that do need to be addressed and that we are addressing? You know, this organization, we have actually filed grievances against prosecutors that we thought needed to be investigated. So we're doing a lot of things at our level, including, and as I had told the senator one time when I met with him, the best thing that this body of government ever did, by far, was create NYPTI. Because before that, prosecutors didn't have the training that we have now. We didn't have the ability to come together and work together. When I started in '92, I didn't know the district attorney in Bronx County. Not only do I know her now, she's a friend, and if I needed help, I could reach out to her. So because of what you created with the Prosecutor Training Institute, a lot of the things that have happened in the past won't happen in the future. So I just ask you to consider what we have and consider what the Justice Task Force is doing and what their, you know, what their recommendations are before we create an entire brand new body of government to oversee something that is actually already being overseen. Thank you.
I'm violating my own rule. I just got to follow up because this is the crux of the whole situation. With respect to the grievance committee, I'm not aware, and I've asked everybody to tell me of a situation where a grievance committee, and they're different all throughout the states, depends on who what the local talent is in that locality. But can anybody give an example where, in view of all the cases that have been reversed, in view of all the people who have gone in jail that unjustifiably, one case with a grievance committee has seriously disciplined a district attorney?
There was one out of Queens many years ago, a man named Stewart, who many, many years of abuses. He finally crossed the line and lied to a judge in open court with respect to the whereabouts of a witness. He said he didn't know where the witness was. As it turned out, he did know where the witness was. He was eventually brought before the grievances committee. And I don't know if he was disbarred. He certainly was suspended from the practice of law. And a few years ago, he reapplied to come back into the legal profession. That has not yet been granted. That's the case that I know of.
Okay, excuse me 1 minute. We have an anxious member of the audience that's standing up. Would you identify yourself?
Robert Masters.
And why do you rise, as a judge would say? Why do you rise?
I'm an executive assistant in Queens District Attorney's Office.
Okay, maybe you can be with the next panel. Your DA is right there.
I think I can inform, no, my DA is not here. I can inform that case, actually. That grievance occurred as a result of our office making the grievance itself. When we were the ones who investigated, found the problem, recommended the grievance discharge Mr. Stewart.
Okay. And that's it, huh? That's the only example we can get? That's number one. Number two, there's something going on in St. Lawrence County now. The prosecutors are obviously aware of that case. I'm not going to get into the details. It's not really necessary. It's my understanding that the current president of the DA's Association actually took some action in order to get a public official to do something about what's going on by the DA in St. Lawrence County. Can you explain to the group here what the present president of the DA's Association did?
Sure, absolutely, and I think it emphasizes the fact of how the system does work. First of all, she is presumed innocent at this point. And I can't emphasize that enough, as every defendant we deal with every day is presumed innocent until they're found guilty. But based upon the allegations that were being disseminated mostly through the press, the District Attorneys Association, through our president, Tom Zugaby, we personally sent a letter asking that she be investigated by the grievance committee. So there's a perfect example of the committee we doing what we have to do ethically. There's an ethical rule. If we believe that there might be something going on that's unethical, we have to report it. And we did that. and it's being investigated. And you know, and I have the utmost confidence that it will be properly investigated, and they will, if they find something wrong, she will be punished according to what they feel is the appropriate punishment. In addition to that, I think she's an elected official. She's going to have to face the public too. I mean, you know, there's something too that I think sometimes gets lost in the mix. When prosecutors don't do a good job, and when they are very controversial, they usually don't get reelected. And I mean, the public, especially today, with you know, the social media that's out today, trust me, if you ever want to know how bad you are, you can just Google your name.
we run every 2 years, okay?
I know.
And I've been the subject of many articles in all the papers. But I guess my question is, why wait 4 years for someone to continue conduct? And let me make one other point. There's an individual who submitted some testimony, and I'll make it public. Her name is Karen St. Hilaire. She was the county manager up in St. Lawrence County. I won't get to the details of her complaint, but she made a complaint against the same DA in July of 2014 with the Committee on Professional Standards. Never heard a thing as of today. She then went, and this is some of the early activities that are now becoming public. She then made a complaint to the Public Integrity Bureau of the New York State Attorney General's office. She was sent an acknowledgement that they had received the complaint, assigned a case number, and has had no response other than that, and that was 2 years ago. So I guess I understand what you're saying, and I'm just trying to find the proof that the current system works at the present time, and that's what I'm looking for. And if we can now go to, I'm not sure who's who, but is it Kian Katabi?
Kian Katabi, yes.
Yes. Could you please testify now?
Good morning. My name is Kian Daniel Katibi. I'm an honors graduate of New York University as well. I hold a degree from the Benjamin N. Cardozo School of Law. Recently, I passed the New York State Bar, and my application for admission as an attorney to New York State is currently pending before the First Department. Having said that, while I'm pleased with my recent accomplishments, at this stage in my life, I would have far preferred to have already had an established career path. One of the reasons that is not so, if not the only reason, is that from 1999 until 2008, I was incarcerated in New York State as an innocent man. Those years were accompanied by criminal proceedings attached to the head and the tail. Please allow me to give you a little context. In 1998, 2 young men were stabbed outside of a local bar in Pleasantville, New York, Westchester County. That's my hometown. The men were so intoxicated that they did not know who had stabbed them. Over the course of the investigation, what had been ultimately a faulty case had been handed up to the District Attorney of Westchester County. How and why the prosecutor in that case decided to go ahead with and try the case is beyond my realm of knowledge or understanding. However, there were certain actions. Let me get right to the point for the purposes of this hearing. In 1999, before my trial, the district attorney had agreed to a consensual discovery request from my defense attorney, which meant that they would simply consent to giving over everything I was allowed in discovery, which included the victim's medical records. And they agreed to do that by a certain date. About a week before trial, much of this was not handed over yet. A few days before trial, the medical records of the victims arrived in my defense attorney's office. He noticed that a few pages were missing, so he subpoenaed the medical records. When they arrived the morning of the trial, the front page of the victim who I was being tried for his assault, the front page of his medical record indicated that he had stated upon admission to the attending nurse, "I had 14 drinks, beer and whiskey. I don't know what happened. I wrestled with some guys." Now, this was pretty important information for my case, my trial, where no one had actually said that I stabbed anyone. and where the victim had said that he'd already been on record testifying that he had only 1 or 2 drinks, he recalled what happened, he didn't wrestle with anyone, and that it must have been me that stabbed him because I was in the area. Certainly this is good information to withhold from the defense. Having arrived the morning of my trial, that information, we were unable to locate the attendant nurse to get her to testify for trial in time, and that evidence never made it before the jury. I was ultimately convicted. I pursued appeals. I reviewed my records. I studied the records, and I found there was allusions to statements being made by certain witnesses. I filed many Freedom of Informations against the district attorney. I pursued Article 78 motions and appeal to get them to disclose the criminal file that I knew they had. I had the record there, which statements were made. They resisted every step of the way. Every single response that they said to me was, in the response, even to the court, was, we reviewed the record and the police file. There's nothing here to indicate this. We reviewed it very thoroughly. This went on for years. Finally, in 2008, after confession of the true assailant, I was granted a 440 hearing in Westchester County Supreme Court. I remember the morning of the hearing that summer in 2008, I went before the court in Judge Zambelli's office. As I went in, she made an oral decision on an order for discovery, and she, right then and there, ordered the district attorney to disclose the file, including the police file, for the purposes of the hearing, which you would assume would be very relevant to this case where there's a colorable claim of my innocence, having had the confession of the true assailant. At that time, the district attorney got up and stared right at the judge, is somewhat trying to be convincingly saying, oh, the file is missing, it's gone. We don't have the file, it can't be produced, and it won't be produced. I wasn't the only one surprised or in doubt. Actually, at that moment, I recall to this day Judge Zambelli taking off her glasses, getting red-faced, and storming out of the courtroom and saying, go check while we're on break. No file appeared. I went on with my hearing. I guess it's just by the grace of God or sheer luck that the confession, along with other evidence which was adduced at the hearing, my conviction was ultimately reversed, and I was exonerated. Throughout my appeals, I had consistently, my defense was, nobody had stated that I did the stabbing at trial. This is not sufficient evidence for guilt. Each and every response from the district attorney in their papers, in their briefs, in their letter motions was that 2 people had identified me as the attacker. It's simply not true. There's nothing in the record to indicate that. And I can tell you, it's hard enough to win an appeal, the presumption being against me after a criminal conviction, without the district attorney misleading and giving false or misleading information in their responses. I have to question at this time whether they really, throughout this whole ordeal, had thought that I was guilty or not. A lot of their actions indicate that simply they may have not have cared at all. I know my time is limited here. With that said, I would just like to thank you for your time.
Just 2 very quick questions. Was any disciplinary action or any action taken against the district attorney?
No disciplinary action was taken against the district attorney, sir, to my knowledge.
Okay. With respect to, and I don't want a number, did the state of New York have to pay any money to you for the wrongful conviction? I don't want a number.
I went through a trial, and in 2010, the Court of Claims, a judge trial, bench trial, the court had found that I had proved by clear and convincing evidence my innocence and that I had not contributed to my conviction, and an award opening the door for liabilities. Ultimately, there was a settlement.
Okay, thank you very much.
You're welcome.
If we could now go to try to keep this balanced, I believe we have...
Excuse me, Senator.
Yes.
I just wanted to note that we've been joined by Assemblywoman Helene Weinstein,
yes.
Chair of the Judiciary Committee.
Bennett Gershman, Professor of Law and former Manhattan Assistant District Attorney.
Thank you.
Could you grab the mic and...
Yeah, you can take it.
Okay. Thank you, Senator and panel, for inviting me to be here today. When I started writing my this treatise on prosecutorial misconduct about 30 years ago, I researched hundreds of cases where prosecutors had engaged in serious misconduct, and I noted that these prosecutors weren't disciplined. And I said that at that time, and it struck me that this is a illogical situation. I mean, prosecutors wield more power than anybody in our society lawfully. They can deprive people of their lives, their liberty, and they can destroy people's reputation. And there really are, as I found, no consequences. There are no consequences. I can't think of any other official in our society, any other person in our society who commits violations of rules, and there are no consequences. Now, I wrote about it, and other people have started to write about it. And so I think it's incontestable that prosecutors in New York State do commit misconduct. We're not talking about, as District Attorney McNamara said, we're not talking about mistakes. We're not talking about errors in judgment. We're not talking about refusals to prosecute. We're talking about blatant, egregious, flagrant misconduct. And it happens a lot. Now, I think the vast majority of prosecutors in this state are honorable people. And I think they would welcome a commission. Because when a prosecutor violates the rules, as so many of these prosecutors have done, it taints everybody. Now, you know, when Mr. McNamara said there's going to be a chilling effect on prosecutors, they said the same thing when the Judicial Conduct Commission was created. Chilling effect, the judges aren't going to be able to do that. You know, no, that's not right. Prosecutors will vigorously do their job fairly, ethically, and that's all we care about here. We care about ethics, and right now it's incontestable that prosecutors are not held to account for their misconduct. In the Rudin article, he subpoenaed records from the DA's office in Queens and the Bronx, over 70 cases where judges found serious misconduct. The DA's office didn't want to say who those prosecutors were. Finally, the judge in discovery said, give them the names. They got the names. None of these prosecutors, none of them were reprimanded, were brought up on any disciplinary charges at all. And in fact, when they got the records, the personnel records, you know what happened to these prosecutors who committed misconduct? Yes. They were given bonuses, they were given raises, they were promoted in the office. Can you imagine that? How does that really make the average person feel who has been sent to jail for 25 years, who's innocent? New York State ranks second among all the states in terms of exonerations of the wrongfully convicted. And the prosecutors, in about a third or close to a half of those cases, the prosecutors contributed to those wrongful convictions. That's fantastic. That's just hard to really imagine. And it's hard to imagine that prosecutors are not held to account. I think I'm going to stop right there. I laud the courage of...
So, Professor Gershman, I wanted to ask a question to Mr. Tembekian, because I still didn't get a full answer to my question that I asked Mr. Schechter. So what I want to know is the situation of a judge prior to this commission that was formed in 1970, whatever. What was the disciplinary proceedings like for judges at that time? Was it similar to what we are hearing in the testimony that's being given today?
Yes, in the sense that the authority to discipline judges was diffused. It was spread out among 5 different entities of the court system. What was different was that the judicial disciplinary structure before there was a commission effectively had no staff, and it was ad hoc. If a complaint was made and it got to the court system would assign people to investigate them. But
this was on the court on the judiciary, which was the first step, right, of attempt to rein in bad judges.
And also the appellate divisions had authority, but they didn't have a staff. They didn't have an office that actually was responsible for conducting these investigations. If a complaint on a lower court judge made its way into the court system, a staff person within the court system was essentially
But
assigned
even prior to that,
investigate.
was it just the disciplinary commissions of the disciplinary committees of the appellate divisions that would discipline judges just like other lawyers? That's really what the heart of my question.
It wasn't the grievance or the disciplinary committees, and in fact, as you know, there are 2,000 judges in New York State who are not attorneys. So they would not have been under the disciplinary committees in any event, because the disciplinary committees are literally limited to enforcing the rules against attorneys. But judges were disciplined, if at all, and there were relatively few before the commission was created who were disciplined either by an appellate division or by the court on the judiciary, not by the grievance committees. But the structure was diffuse, it wasn't uniform within the departments.
Thank you.
We now ask David Soares, DA of Albany County.
Thank you, Senator. First and foremost, Senator, thank you very much for this opportunity to be here and to share my thoughts personally, as well as my thoughts as a member of the District Attorneys Association of the State of New York, an organization that I am proud to be with representing. I come here today with a full appreciation of where we are right now, not only in the state of New York, but where we are right now in this country with respect to criminal justice issues and criminal justice reform. There's a lot of discussions going on at the federal level about sentencing reform, so many different issues. And there's a lot of effort and energy being placed in changing the criminal justice system, a change which I think is very necessary, as we've all seen and we understand the impact that the criminal justice system has on certain people. The one thing that I've always marveled at ever since becoming a district attorney myself is how little attention is actually paid to county district attorneys. We do have a lot of authority. We make very important decisions. And if you want reform, then generally speaking, that reform comes from local communities. We all practice law. We all use the same penal codes. We all use the same criminal procedure laws in the state of New York. And based upon the demands of our communities, we practice it in a way that reflects the wants and needs of our communities. Albany County, I can say Albany County is a very progressive community because that's what our constituents demand of us. Albany County, we have a unique relationship with our communities because that's what the citizens of Albany County demand of us. And I say this to you because I think, for me personally, being here as well as a representative of DASNY, I'm not here to tell you what you should do. I'm not here to scream or bang a table, and but I am here to provide you with my own personal experience as a sitting DA as to what I've experienced in my 3 terms here in Albany County. And I offer the words that I'm going to offer here today as just some guiding posts for you to consider as you proceed down this course in arriving at your determination. Ultimately, if there is a commission that gets to oversee the work that I do, that's a decision that's going to be made by the same people who've elected you that have elected me. And we have
may I correct you, Mr. Soares, that this commission is not intended to oversee the work that you do. It's a commission on prosecutorial conduct, and it will only take up complaints that's brought to the commission based on what happens in conducting your job. And not just, there has been a lot of emphasis on the district attorney, but this commission will be responsible for disciplinary issues pertaining to all prosecutors, those people who you appoint as district attorneys, because a lot of the problem that exists comes from those working under your supervision and authority that sometimes are not facing the disciplinary action that is necessary for their conduct. Thank you.
Okay. Well, Assemblyman Perry, then I stand corrected as to what the focus of the commission is going to be. And I guess without getting into a question and answer segment back and forth, I would first ask you to consider whether or not the complaints that are going to be filed, whether this commission is going to be entertaining those complaints as investigations are going on, as criminal prosecutions are going on, or after the completion and termination of those investigations and prosecutions. That's something that has to be seriously considered by this body as you move forward.
I think the answer to that is it'll be modeled after what the judicial model is, because I'm sure that judges still continue their trials and continue their work during the course of their investigations, but I would leave it to Mr. Tembekian to tell us otherwise.
Okay.
Generally speaking, the Commission on Judicial Conduct does not involve itself in matters that are pending, but there are exceptions, and there are logical exceptions. If the complaint, for example, is that the judge is delaying unduly, and that delay stretches into years, and if we wait until a decision, which may never come, before we ask the judge what's taking you so long, it would be self-defeating. But generally speaking, where litigation is ongoing, we tend to step back.
Thank you.
So that certainly is an answer. Check that one. There's also the question as to who may file a complaint against a prosecutor or someone working under the direction of the district attorney's office, and whether or not the complaints are in fact sworn under the penalty of perjury, like a complainant would be making in the criminal justice system. Those are some issues that we would hope that you would consider. The commission would have unprecedented power to compel the district attorney to testify against himself or herself. And so another legitimate question, a legal question, would be whether or not the district attorney or the assistant district attorney would be receiving immunity for purposes of those complaints, which is often the case if we're compelling testimony from a defendant in the criminal justice system in the grand jury. One of the other issues that we're very interested in knowing is whether or not the commission would be bound by the same evidentiary rules as we have here in the criminal justice system, and what the burden of proof would be to sustain a complaint against a prosecutor or an ADA. The other issue that I've had personal experience with, and one that I think is very, very important here, is whether the commission, and I think you've answered it based upon the fact that you've stated that this would be modeled after the judiciary model, and therefore this hearing wouldn't be going on during an active prosecution. So I guess the question is to whether or not this commission would provide additional opportunities for discovery that defendants would not be otherwise entitled to under the criminal procedure law. If it's happening after the prosecution, then I guess that issue is moot, if I'm hearing what you've just stated, correct? So this would
Yes.
be, okay.
I mean, I could be rude and say that we could offer you the same kind of discovery as criminal defendants are offered in the state of New York by law.
That's not rude for me. That wouldn't be rude for me at all, sir. The other issue that I would hope that this body would consider is the issues with respect to identity and personal information that's contained in a prosecutor's file, that would not be subject to disclosure for purposes of putting out pertinent information regarding victims and witnesses. Those are things to be considered as you consider your commission. The other issue is whether or not this commission would take the place of the current commission in the 3rd Department that oversees conduct for prosecutors as well as all attorneys, or whether or not prosecutors would be subject to more disciplinary than an attorney with a defense attorney per se. And we would like to know that answer as well. Without getting into, too many other issues, and I think some of them we've discussed here. Currently, as it stands, it's the executive branch that has the authority to remove a sitting prosecutor. And we were wondering about the constitutionality of the legislature usurping the authority of the executive in being able to remove a sitting prosecutor, and where the law that would support a legislative body from usurping the executive authority at this point. Also, one of the issues, and there's a lot of important issues that need to be discussed.
I think that,
I just real quick to respond to your, the legislature usurping the executive. He does it to us all the time, so I don't think we have to be problem. But
did I open up a can of worms?
But one of the things, and I'm from Suffolk County, and obviously we've all read what's going on out there, and I'm going to let the process play out, but there's certainly a lot of bad allegations, and we'll see what happens in the coming months. But as a result of that, our county executive has demanded the resignation of our district attorney, saying he's running a corrupt organization.
No.
And he has said that he's called for the governor to remove him. And so they did a little history, and I think it's happened one time many years ago where a governor actually did that. So that may not be the answer we're looking at too. That does about as frequent as
As a prosecutor being disciplined.
Exactly.
I just want to stop picking on the Bronx.
6 months in.
We do enough of that in the association.
He's talking about the old Bronx.
Yeah, exactly.
So David, I just wanted to also suggest to you that your allegation, what you said about the usurpation of authority, the governor would make that decision because he'd have to sign the bill as to whether or not he or she wanted his power to be usurped in matters of this nature.
Thank you. The
Now,
last issue
may
that
I
I...
also
sorry.
just add to that is we are very much aware and took caution to not step on the powers of the governor. Final action, if there's a determination to remove a sit-in district attorney, would remain the governor's act, in the governor's authority. We do not propose a commission with the power to remove a district attorney, but the result of the investigation and the recommendation would go to the governor, and he would act under his constitutional authority in that case.
Okay. The other, and one final point that I'd like to make, and I know that there have been some comments about my colleague's reference to a chilling effect. There is a very realistic issue here that we have to deal with, and that is an assistant district attorney who starts off his or her career earning $50,000 to $55,000 a year, being subjected to the commission, and whether or not there are counties that believe that they should represent prosecutors, county attorneys' offices that believe they should represent, and then there are counties that do not represent their prosecutors. So there is that expense that we should also talk about, and if we're going to talk about that, whether it's there's something that has to be done by way of including language about that kind of support and representation in whatever this body decides.
Thank you. We have, thank you all for being succinct and to the point. I really appreciate it. David McCallum, the last person in the first panel, if you would please provide your remarks.
Sure, thank you. Good morning, everybody. This issue hits home to me in a very, very personable way. I think whenever we talk about prosecutorial misconduct, we're hitting at the heart of the criminal justice system when it comes to the district attorney's office in general. I wouldn't be sitting here if I, first of all, I would be remiss if I didn't mention that I would not be sitting here if not for a change in Brooklyn in terms of district attorney's office when Ken Thompson took over. Mr. Thompson agreed to look at my case in a very different way as opposed to the previous prosecutors, meaning Charles Hines and Elizabeth Holtzman, for that matter. So I just want to be very, very clear about that. But I was sitting in prison for 29 years because of two legs of the prosecutorial misconduct. For one, there was an individual in my community who was a known informant, a career criminal, who we only found out decades later he was involved in some very, very shady operations with the law enforcement in my neighborhood. We also learned later on that this individual made deals with the prosecutor in exchange for his testimony. So this individual was allowed to testify falsely, we believe knowingly, by the prosecutor, who stood by and did nothing to correct this gentleman's testimony. As a result, we believe that contributed heavily in our conviction. And so when I say our, I'm talking about myself and my co-accused, Willie Stuckey, who unfortunately passed away in prison in 2001. So when I talk about this hits very, very home with me and it's very personal, I really mean that, because Mr. Stuckey, in my mind, should not have been in prison in the first place. So when we talk about, well, I think one of the words that come to mind for me when you talk about an issue like this is transparency, or lack thereof. There's no transparency when it comes to disclosing information and evidence and documents by the district attorney's office. From my experience and doing my research in prison, I learned that the prosecutors, not all of them obviously, but some of them at least, they really talk a good game when it comes to evidence that's stored and evidence that's not disclosed. So we are led to believe, and we're at the mercy of these prosecutors. So I should just remind this panel, we're at the mercy, meaning myself and people like Mr. Katibi, is at the mercy of these prosecutors, because we have no way of knowing what's available and what's not. And so for me, I think one of the ways that we can sort of, help out that situation a bit is at least, work towards this real transparency that I'm talking about, is to hold in-camera inspections of documents, prior to the case going to trial, for that matter. So, for example, if the prosecutor gets a hold of information that's helpful to the defense, he or she should be obligated to turn it over to the judge for an in-camera inspection. That way, the defendant and his attorneys, of course, will have an opportunity to vet this information and this evidence and these documents out to see what can be useful and what can't. But that doesn't happen in today's criminal justice system, and I think that's sort of like a black hole. It's really a black eye in the criminal justice system, because as long as these matters,
I just want to correct you, sir. I want to correct you to tell you
Sure.
that it does happen in our criminal justice system, just not in New York and a few
Oh,
other
yeah, so let me be
states.
more specific. I just thought, obviously, I just thought it was
No,
just, don't talk
you're
about
right.
New York
I just
State.
wanted to let people aware, because the general public is not aware of it, because they watch Law and Order and they think that discovery, open file discovery, is the law of the land,
Yes.
but not in New York.
Okay, well, yes. so-
It is in Albany.
Yes.
But that's by the grace of the district attorney who's presently serving, is it not? Thank you.
Okay, thanks for that tidbit there. I appreciate that. So as far as I'm concerned, and I don't mean to speak for anybody other than the case that I'm here to represent, which is myself and Willie Stuckey, that prosecutorial misconduct is a very serious issue to me, and I just think if something seriously is going to get done about this particular issue, it really has to happen today. And it starts with this hearing here. So for me, just to be able to discuss this issue and just to talk about why this happened, I think these are questions that are sometimes not really answered, they're parroted in some ways, but they're not necessarily answered. I just think that's unfortunate, and I think we, as a panel and as an area, need to sort of get to the bottom of this particular issue.
Thank you. With the consent of the other panelists here, could any problem in those that haven't spoken come forward, and those that sit back there? And then at the end, if we have any questions of anybody, we can do it at that time.
Great idea. Thank you.
Okay, can we switch seats there, except for the Bronx DA, the new Bronx DA?
Unbelievable. Just listen to this again. You're going to cry.
The technical stuff. Technical stuff.
Looks like you're getting ready to try a case with all that stuff you
Yeah.
got with you. Look like you're ready to try a case with all your briefcases. Okay. Okay, I'm not sure exactly who is who, but what I'd like to do is start off like we did the last panel with the Office of Court Administration, and without, I'm sure you have some remarks that you had in mind. Stephen Downs, past Chief Attorney of the Commission on Judicial Conduct for 28 years?
28 years.
I think the thing that's most interesting to me, and you can go on and expand on other things, but there's what I want to get in your testimony, whatever point you want, what the experience was in the outset of the commission and how that evolved as far as the public perception of it and the judge's perception.
Right. I'm glad I'm following Bob Timbetchin because he had, we've been colleagues for many years with the commission, and he gave very good description of how we began. I was a little bit before him with the commission. I was literally in on the door. We spent a week sitting on the floor waiting for the furniture to arrive. But the creation of the commission itself arose from a kind of a crisis of confidence back in the early 70s. Jack Newfield had published an article that sort of described the 10 worst judges in New York, and it sort of fed a public perception that there was no effective discipline for judges, and that judges were free to engage in any misconduct. So that is really a lot of the impetus that brought the commission together. At the time, there was a lot of opposition from the judges. They said this was going to interfere with judicial independence. That was the big thing. And I think after a couple of years, we began to get feedback from the judges, and their feedback was exactly the opposite. They said, you know, actually, this enhances our independence. And I just want to give you one example of how that happened. At the time, we got involved in a investigation of ticket fixing. There was a practice in upstate New York particularly of one judge sending to another judge a letter on judicial stationery asking for favors for constituents. And at one point we had 250 judges under investigation. And when this all sort of came out, the judges began to say, you know, in our situation, we got a lot of pressure from politicians, from people of influence, and we thought we had to do this. We thought this was part of the job. Now, because the commission is there to enforce the rules, we have been made independent. We can say, no, we don't do that anymore, and we are free to do our job. And what I think would be true, this is true of any professional, because all professionals are under pressure from time to time to cut corners, to give favors to the well-connected, and if there's no enforcement mechanism, you're just forced to do things sometimes that you think are not right. Now the prosecutors can say, sorry, we don't do this anymore. We're not going to rush a prosecution when we're not sure we have a case, just because you want that. We have our ethical obligations, and they are enforced, and we're going to stay with it. So in my sense, I think this kind of a commission actually enhances prosecutorial as well as judicial independence. And I wanted to just say that I think one of the advantages of something like the Commission on Judicial Conduct, and I've been very proud to be associated with it over the years, was that it was a model of litigation. That is to say, it didn't just give due process. It tried to give to the judges that came before it a model of what really good due process litigation would look like. And I just happened to have been a lawyer on a case involving the Commission on Judicial Conduct, and I was very impressed at the time that they gave me all of the discovery that I was entitled to very promptly. They cooperated with everything. They made it a pleasure to be a part of litigating, and I think that kind of a model is good, particularly with prosecutors. You don't necessarily want to be prosecuted as a prosecutor with the same standard that a lot of defendants get when they get into court. I just want to say a few comments quickly about the Commission on Prosecutorial Conduct. One of the big features of this model is that it is truly independent, and it is perceived as being independent by the public. And I think that is necessary to develop credibility. The present system, which as you've heard, is private, it is clubby, it is done within a small group of people, and it is not perceived as independent. And so its results, whatever it does, is not going to be credible, no matter what would be done now to change it. One of the composition of the Commission on Prosecutorial Conduct is particularly important because under the statute, it requires that all of the players in the criminal justice system, the prosecutors, the defense bar, and the judges, are present on the commission and can engage in the kind of creative discussion that is going to lead to a very progressive way of disciplining prosecutors. This is not going to be the kind of closed system where the prosecutors dominate and so nobody gets publicly disciplined. The legislation provides for a direct appeal to the Court of Appeals. This was very essential, in my view, to the success of the Commission on Judicial Conduct, because that gave the Court of Appeals the ability to speak on the kind of judiciary and the kind of criminal justice system they wanted. When the when the Court of Appeals upheld what the Commission did, it very much strengthened its hand. It made it appear to be the kind of real oversight body that it was. And when the Court of Appeals disagreed on those rare occasions with what the Commission on Judicial Conduct did, it essentially indicated that there was oversight over the Commission. So it reassured the judges that they were not dealing with a commission that was exercising arbitrary power. I want to also just...
do you believe that it had any kind of a chilling effect on the operation of any judicial?
No, I think it actually enhanced it, as I've said. I think and I've heard from a number of judges to say, we are now proud to be judges. We feel we have been given independence. The real problem, for most people is not living under the rules. The rules are not that hard to live under. The problem is resisting people who want you to get around the rules and change the rules and do things that are not there or shouldn't be there. And that's what the Commission is set up to prevent. And so it makes it much simpler. Now you don't have to deal with all these other issues. You just follow the rules. In my view, I think that is just a much simpler, easier way to deal with your profession. And I wanted to make clear that the grievance committees, as I understand it, and Bennett Gershman is really the expert on this and can tell you more if you want to know more, but my understanding is that the grievance committees basically do professional standards, and there's not a great deal in the professional standards that deals specifically with prosecutors. There are a number of other codes. There's case law, and there's also the ABA standards for prosecutors, which are much more complete, but that has never been adopted officially in New York. The present legislation does adopt that, and so it gives the disciplinary body, or the Commission on Prosecutorial Conduct, a much broader and more complete picture of what it means to be a prosecutor and the kind of rules prosecutors should follow. And I also have to say that one of the last thing, and I'll just quickly wrap up with this, the Commission on Judicial Conduct for years published an annual report, and in that annual report, they commented on various things that they had discovered that needed reform. And over the years, a number of reforms were adopted. And I assume that the Commission on Prosecutorial Conduct will do the same, that they will find things in our somewhat antiquated prosecutorial system that need improvement or updating. And they can make those recommendations, and in the process, I hope, slowly bring about in New York State an adoption of best practices. We have a very fractured and decentralized prosecutorial system, and getting the word out about what are new innovations, what are better practices to follow, is a very slow process, and hopefully this is something that the Commission could advance. So with that, I'll rest and take questions if anyone has any.
Okay, thank you. Next, it's a Darcel Clark.
Yes.
Former judge, now the District Attorney for Bronx County.
Good morning, and thank you for this opportunity to appear before you on this very important matter. Yes, I am Darcel Clark. I am the current District Attorney of Bronx County, newly minted, I guess you would say, in office for 6 months. So anything that happened before that, you can't blame it on me. But at the same time, because it was my office, because it's part of the history of the District Attorney's office, does not mean that I'm going to ignore the things that have happened in the past. by far, one of the things that I am doing is as I'm going through the office and doing a number of reforms, I have to learn lessons from some of the things that happened in the past. I just wanted to give some other incidents where prosecutors have been held accountable for the conduct that they have. I have a number of cases here. Hayter versus the Committee on Professional Standards, a third department case in 1982, where a prosecutor was censured for their conduct. Brophy versus the Committee on Professional Standards, a third department case from 1981, where that prosecutor ended up being convicted in federal court of a misdemeanor of depriving a person of their constitutional rights based on the work that they did in the office. That person was ultimately disbarred, but then it was overturned and later they were censured. In 2011, in Ray Muscatello, second department case where the prosecutor there, Assistant DA, received a 1-year suspension for going before the grand jury with a blank chemical test in a drug case and indicating to the grand jury what the results were, even though they weren't on the test. And that prosecutor knew what the results were, but from other evidence, not the evidence that was presented before the grand jury. So that person was censored and then ultimately received a 1-year suspension from practice, was later reinstated. Then I have another case in 1990, a fourth department case, Curtis Lyman versus the Grievance Committee, 8th Judicial District, where this particular assistant DA represented clients while simultaneously prosecuting those matters as a DA. So the person was a DA, but at the same time was representing clients. That person was censored as well. So I don't think you can say that the system that is in place doesn't work. And yes, I have another one, in Ray Ross from a first department 2000 case, a joint disciplinary proceeding against the ADA and her husband. At the request of her husband, he tried to use her position to undermine a traffic summons, and she got fired. Conflict of Interest Board fined her $1,000, and she got censored. I actually know these particular individuals because I was in the office at that time. So the present system can work, and there's just a fundamental misunderstanding of the existing systems. Prosecutors are held accountable for their wrongdoing. We have internal trainings, ethic policies, judicial oversight during trials, the appellate process, and the grievance committee procedure. All of those things hold us accountable. Internally, I can tell you, as a new DA, I can personally tell you that prosecutors now are working really hard to train their assistant DAs to meet every disclosure obligation required. District attorneys are going beyond the law and disclosing the information that needs to be turned over. Look, we read the papers. We know what the present climate is. It's not easy being a district attorney these days, but we do have a job that we have to do. And we know the complaints of the public, and we know how you feel as the legislature. But through the efforts of the District Attorneys Association, which I am here to represent as well as the New York Prosecutors Training Institute, NIPT, we across the state are meeting, we're creating best practices and ethics networks through publications called The Right Thing. I think we sent that to you, Senator, and the Assembly as well, which is a book we distributed statewide that talks about the best practices and the ethical obligations of assistant district attorneys. But so we're not ignoring it. And I think that you will see now all across the state, new district attorneys are being elected, like myself, that are willing to do and are doing the right thing as frequently as possible. Last week, the Putnam County DA consented to overturning a conviction. I've been in office 6 months. I've done it at least 2 or 3 times. District attorneys are different than they used to be in the past. And we are turning the corner, and I like to say that we're turning, the right corner to make sure that we're doing our obligation. You have to realize that this is an adversary system, And we have to be able to do our work without fear or favor, and that's what we do each and every day. And with these, with court proceedings, with the Brady rules and Rosario and Giglio, we are constantly reminded of the things that we have to do. I talked about the voluntary discovery practices, voluntary discovery. My office goes beyond what is required in the statute 24020 to make sure that we turn over. Defense attorneys, when they're preparing their cases, they ask for discovery and they make sure that they tell us what they need if they don't think they have what they've got, what they need. In the trial courts, the judges are the gatekeepers, and they're at the bottom line to ensuring that there's a fair trial. And if assistant district attorney gets out of line, the judge has every opportunity and the authority to stop things before they go wrong. If the argument is inappropriate, you know, you could tell the jury to disregard it. If they keep doing it, the judge can declare a mistrial. The judge can keep evidence out that doesn't belong in. We're constantly being checked throughout the process, the criminal justice process, leading up to and during the trial. Again, if the prosecutor fails to disclose evidence, you know, there are sanctions for that. Disregard evidence, adverse inferences, again, all ways to make sure that we do the job properly. And then on appeal, of course, judges review the prosecutorial errors in the appellate division, and we're reviewed as to whether or not we did something wrong. And with the appellate division, which I know firsthand, having been a member for 3 years of the appellate division first department, the appellate division has the power not only to look at the errors that happened during the trial or errors of law, but they also have an interest of justice power, which not even the Court of Appeals has. So even if something wasn't preserved for appellate argument, the appellate division has the right through the interest of justice power. There's also a number of ways that defendants pursue their claim of prosecutorial misconduct. There's motion practice. They can move to set aside the verdict under CPL 330. There's a motion to vacate the judgment under 440. Defendants have appeals as a matter of right. They have appeals as a matter of the court's discretion. And of course, there's writs of habeas corpus in the federal courts. So there are a number of ways that, you know, we have checks and balances on prosecutors. But win or lose, anybody can file a complaint with the grievance committee against a prosecutor. And I would say that we could be easy targets at times because, trust me, when we do our work, there's always an unsatisfied customer, unfortunately. But we're trying to do justice, and we're not always going to be popular.
Welcome to our world.
Huh?
Welcome to our world.
Yeah, exactly. Well, I mean, anyway, I'll leave that alone.
No,
yes.
thank
Anyway, we can be censured, suspended, or disbarred because remember, you have to remember that prosecutors are attorneys. Setting up a separate commission, that means that, you know, there are going to be two systems in place. This could go one way, somebody could make a complaint through the Prosecutorial Conduct Commission, and that commission can come up with one recommendation or finding, and if they're also subject to the disciplinary committees or the grievance committees, can go through that channel and something else. Who decides? You know, how do you know which is right, and why should we have to be subject to two different systems when there's one in place? I mentioned that there are cases where prosecutors are held accountable. And before I became DA, of course, I told you I was in the appellate division. I sat on panels of appeals where there were mentions or allegations of prosecutorial misconduct. And I could tell you, we ruled against and made determinations on the conduct of prosecutors in those cases. And I sat on, you know, a number of reversal cases because of that, and defendants received new trials. At the same time, as a member of the appellate division, as an associate justice, we are the ones that hear the recommendations of the disciplinary committees and determine what sanctions, if any, there should be against a particular attorney, whether it's a prosecutor, a defense attorney, or any other kind of attorney. And I know that firsthand because I've sat on those panels and made determinations on whether or not somebody should be censured, public censure, private, disbarred. That is the power of the appellate division. So those things are there and in place. And besides the grievance committees, of course, and we talked about some of these things already, that the governor has the power to remove a district attorney. And of course, the Bronx knows that very, very well also, because Governor Pataki did that very thing against Robert Johnson. We know that the media is constantly watching us. In this day of 24-hour news cycle, we're always being watched. So we know that somebody is always watching. And of course, the electorate can vote us out. That is what happened in the Bronx. 27 years Robert Johnson served, and I now sit here as the new district attorney. So, you know, we are doing things, and of course, this legislature has the power to do many things. You enact the laws that we have to follow in doing our prosecution. So, you know, we have to follow that law, and our assistants are also answerable to us as the elected district attorneys. And we demote prosecutors, we require training, we provide remedial guidance, and terminate employment if necessary. So this commission, I know, was modeled after the Judicial Conduct Commission, which I am also very familiar with, having served as a judge in this state for 16 years. So I'm familiar with that process. But one thing we have to remember about the Judicial Commission, I think part of when they started, you have to also remember those rules are necessary because some people sit as judges in this state who are not lawyers, which means that there needs to be some type of oversight of those types of judges, because the other members of the judiciary are lawyers and are subject to the disciplinary process, and the judge is now under the Judicial Commission. So there's constantly a need for, you know, some oversight where there is none. With prosecutors, there is some already because of the fact that we are subject to the grievance committee. I just have a few more things. There is room for improvement.
Excuse me, when you were on the appellate division, do you have a red light? When the lawyer was talking too loud? Okay, let's assume we have a virtual red light here, okay?
All right. I'll wrap it up then. There's, you know, the Justice Task Force has made a number of suggestions that can help the current process. And I think some of the things that need to be done are, for example, for the courts, there needs to be a distinction between error and misconduct. Okay? I think that just because district attorney or assistant district attorney does something does not mean that it's misconduct. It could be error, and the courts need to distinguish that better in their opinions. The court should refer to the disciplinary committee anytime that they find some type of misconduct of a prosecutor or a defense attorney. They need to refer that to the disciplinary committees, and that's not always done. As far as disciplinary committees, some things can be improved there as well. They need to collect the data. Senator DeFrancesco, we met with you earlier this year, and we talked about the data collection, that there's not enough data determining whether or not there have been allegations against prosecutors specifically before the grievance committee. And I think that what they need to do is make sure that they delineate prosecutors when doing their collection of their data. You know, again, the annual report that is put out by the disciplinary committees, they should determine the outcomes of the cases that are brought against prosecutors and what happens. The DA should be notified about any, you know, disciplinary committee decisions. And of course, the most important is public education, because the public needs to know that there is a way for them to make their complaints. Lastly, as far as prosecutors, we're doing training all the time. Best practices, ethical procedures. In my office in particular, I'm telling you, because of things like this possibility of the Prosecutorial Conduct Commission, because of the best practices, because I'm a new DA and I'm overlooking all of the ethical challenges that we face as prosecutors, I'm setting up a bureau for professional responsibility that will have a best practices committee as well as an ethics committee. So we are constantly training and retraining and doing whatever needs to be done, even if it means firing an assistant district attorney if they fail to follow the rules. So, you know, I think in conclusion, I think that we don't have a need for this commission. I think there are a number of things that are already in place. There could be room for improvement, and I'm looking forward to your questions.
Okay, thank you. Could you get the members, or get me, and I'll get it to everybody else, a citation for each of those cases?
Yes, I will.
Thank you. I think logically, the next person would be John Turry, Public Defender, Rensselaer County.
Thank you. Could I just address one thing that's come up several times
Sure.
already? There seems to be this general belief that we need a commission on judicial conduct for judges because there are some judges who aren't lawyers, so they wouldn't be caught by the Committee on Professional Standards. By definition, in 499B2, a prosecutor includes any individual employed by or subject to the direction and supervision of a district attorney. That would be people who are not lawyers.
Well, I understand, and I
So
know.
there is a need for a separate commission. I just want to clarify that particular definitional issue that seems to have arisen several times already this morning.
Well,
Isn't it also true that the number is minuscule of the number of folks who are judges that are not lawyers?
Well, I don't think it's minuscule, but that wasn't the basis for framing.
I mean, I don't know that's
There are a
true or
large
not.
number
I'm
of
asking
judges
a
who are not
question.
lawyers, actually. But there are a large number of individuals who work in prosecutors' offices
Okay.
who are also not lawyers.
Coming from the city, I may not know better. I
Right.
just asked the question because I wanted to know.
Well, in the real world, upstate, we do have judges in town courts, but that was not the basis for the formation of the Judicial Conduct Commission.
Absolutely not, but I just want to
Okay.
make clear that in the
Okay.
definitional sections of this legislation that's been
Gotcha.
proposed, it's clear that if that's one of the reasons why people think we don't need to have a separate commission, it's not true, because quite frankly, the number of non-attorneys who are staff members of prosecutors' offices probably outnumber the attorneys.
Okay. Okay, go ahead.
As you said, my name's John Turry. I appreciate the opportunity, Senator, to speak this morning, to give you some idea of my perspective. My office defends thousands of individuals in criminal cases every year. I've been a defense attorney for over 25 years. I've also been a special prosecutor. I had the pleasure of working for the Commission on Judicial Conduct under Steve Downs when he was the chief attorney of the Albany office. I've appeared in commission proceedings as a witness for the commission. I've appeared in commission proceedings as a witness for a judge. I've also appeared in commission proceedings as the attorney for a judge. I'm a member of the board of directors for NYSDA, as well as the Chief Defenders Association. And in that regard, last week the call went out to all the chief defenders around the state seeking individuals who might consider speaking here today. I won't bore you with the entire dialogue that took place, but I'll give you a little bit of it. It went something like this. Senator DeFrancisco is holding a hearing on the bill that would create an oversight agency for prosecutor conduct. Is anyone able, interested, willing to prepare testimony or to go to Albany to present? First response, I have stories, but I'm worried about retaliation if I were to speak publicly about the incidents. I won't suffer, but my clients would for sure. Will they hide me behind a screen and alter my voice? This is from one of the largest institutional providers of indigent legal services in the state of New York. Second response, I feel the same way. We have a lot of problems here, some making the paper lately, but I would feel uncomfortable testifying. Third response, I'd be happy to help write something, but I have the same concerns when it comes to actually testifying. You should be able to discern a common theme. The bottom line is this: district attorneys and judges hold unique positions of power. The manner in which they wield that power profoundly affects the lives of individuals, whole communities. As any practicing attorney knows, an angry or vindictive judge or district attorney can make you or your client suffer. It doesn't matter if you're a sole practitioner, a member of a law firm, or an institutional provider of indigent legal services. This is a given in the everyday practice of law. Attorneys who practice in a community live in that community, and they have to make a living in that community. And they're painfully aware of the price they pay if they lodge a complaint alleging misconduct. Retaliation can take many forms. Attorneys are fearful to report prosecutorial misconduct. The prevailing mindset is that prosecutors are untouchable, even when their conduct is most reprehensible. Their worst outcome might be the preclusion of evidence or maybe the dismissal of a case. Prosecutorial conduct is rarely reported to the Committee on Professional Standards. I personally believe a commission on prosecutorial conduct would enhance the likelihood that improper conduct would not only be reported, but it would be addressed in a fair and efficient manner. The ability to report misconduct in confidence, coupled with a commission's ability to initiate investigations based on its own complaints, in my opinion, are critical elements to an efficient and effective system. The Commission on Judicial Conduct has proven itself year after year to be an efficient, fair, and reasonable mechanism to address alleged misconduct of judges, and it's an excellent model for a commission on prosecutorial conduct. There was a letter that I read from the District Attorneys Association. It was written in June of 2015 to the Honorable John Flanagan, and it was addressing the creation of the Commission on Prosecutorial Conduct, or as they said, misconduct. I just want to briefly address a few points in the letter. First and foremost, willful prosecutorial misconduct is actually extremely common in New York State. Apparently, the District Attorneys Association is only concerned with prosecutorial misconduct that results in wrongful convictions of innocent people in major crimes. In other words, cases that make news, cases that are big, cases that are obvious. Willful prosecutorial misconduct is wrong, and it must be addressed regardless of whether the prosecutor believes the individual is innocent or guilty, regardless of whether the charge is a violation, a misdemeanor, or a felony, and regardless of whether the end result is a conviction or not. Prosecutorial misconduct has direct and collateral consequences in individuals' lives. People's lives are put on hold, they lose their ability, whether it's to have public housing, income, job, and quite frankly, just plain simply their liberty. The claim by the District Attorneys Association that indigent defendants can pursue claims of prosecutorial misconduct in the state courts by motion or by filing appeals, presumably after they've been improperly convicted and incarcerated, is downright appalling. Why should a defendant have to be convicted as a result of prosecutorial misconduct when that misconduct should not have been allowed to occur in the first instance? If a commission on prosecutorial misconduct existed, perhaps the prosecutor might not be so inclined to commit the misconduct if he or she knew that actual consequences would follow. The District Attorneys Association also claims that the creation of this proposed commission would cause public safety and the fair administration of justice to suffer. Quite frankly, these claims are nothing more than a lame attempt to inflame the public and to suggest that the creation of this commission will somehow create mayhem in the streets and in the courts of the state of New York. I'm confident that the members of the Assembly and the public they represent can see through this thin layer of smoke. The District Attorneys Association, and you've heard it referred to here again today, they refer to a myriad of effective review and disciplinary mechanisms already in place as a reason not to create a commission on prosecutorial misconduct. In reality, those mechanisms are twofold. First, the prosecutors are watching themselves, bringing to mind the old adage of the fox guarding the henhouse. And second, the 4 grievance committees. They generally oversee attorney misconduct. Without a doubt, our grievance committees do good work, and they generally address attorney misconduct. But that does not mean that there's not a need or room for a separate and distinct commission whose sole purpose is to oversee the professional conduct of prosecutors. Prosecutors have extraordinary power, and they should be subject to greater scrutiny. Such a commission, staffed with individuals who are well-versed in criminal law and procedure, would fill a vacuum in the criminal justice system and provide a uniform system of standards and procedures and enforcement. As it relates to self-regulation, one only needs to read the headlines to gauge the effectiveness of self-regulation by district attorneys. Headlines such as, FBI probes district attorney's office, or judge accuses district attorney of misconduct, or Schneiderman sues DA, might be an indication that self-regulation is not working. And I thank you for your time.
Thank you. Although you didn't ask to testify, you apparently are very anxious to say something.
Tom Zuckerby asked me to step in his stead.
Okay, I didn't realize that. You'll be next, but let me call, in order to balance this, Jeff Deskovic.
Deskovic, yes.
Could you go on?
Yeah, thank you. My name's Jeffrey Deskovic. I'm the founder and executive director of the Jeffrey Deskovic Foundation for Justice. which works to free wrongfully convicted people as well as prevent wrongful convictions. I'm also an advisory board member of It Can Happen to You. I have a master's degree from John Jay College, so my views are not going to be shaped solely by my own personal experience, but also by my formal as well as informal study. I started my organization as a first-person advocate because I served 16 years in prison in New York. I was wrongfully convicted of a murder and rape, which I did not commit, despite a negative DNA test. The results of this wrongful conviction was that I was in prison from age 17 to 32. Prosecutorial misconduct was a major factor in my wrongful conviction and preservation of same. Firstly, the trial prosecutor, when the DNA test did not match me because I was excluded pre-trial from results from the FBI lab, one day before officially receiving those results from the lab, from the FBI, he rushed off to the grand jury to obtain the indictment so as not to be able to have to present that evidence. In the furtherance of going against the exculpatory DNA test, which should have resulted in the case against me ending right then and there, the prosecutors suborned perjury on the part of the medical examiner, getting the medical examiner to fabricate findings of an autopsy, findings which he had not mentioned when he initially did the autopsy. It took him 6 months to come up with these findings in order to help the prosecutor get around the DNA test result. It enabled the prosecutor basically to argue that the victim, who had already lost her life and had been raped, he trashed her reputation and insinuated that she had been sleeping around, and so therefore it didn't matter that the DNA did not match me because it could have come from one of these consensual sexual episodes. Not only did he argue that against me, but then he named another youth by name that he falsely claimed that had this encounter with the victim. But he made an improper argument in doing that. He never presented a proper evidentiary standard. He didn't have a DNA test result performed on this other youth. He didn't even call him as a witness. He just made the unsupported argument to the jury. When the hair on the body did not match me, again, the prosecutor resorted to an improper argument that he made without first establishing an evidentiary foundation. He claimed that the hairs must have come from the medical examiner and his assistant. I later learned during the discovery process of successful litigation that I brought once I was exonerated, that when the hair expert learned that that was the argument that the prosecutor was going to make, he requested that the prosecutor provide him with the samples, and that prosecutor declined to do so. That was also never turned over to the defense. I want to add that my civil rights lawyers were able to find 3 additional cases in which the same trial prosecutor, George Boland, had worked with this medical examiner, altering results in order to fit prosecution theory. In addition to that, I also, there was prosecutorial, well, let me just add that nothing ever happened to that prosecutor. When I brought successful litigation, although all the parties ultimately settled with me except for the one party that I went to trial with and won a jury verdict on, the case against the prosecutor was dismissed based on prosecutorial immunity. In his footnote, the judge dismissing it said he felt constrained by the law to do so, but that he wasn't dismissing it because he didn't find that I had evidence or that the allegations were not serious. He noted that I could pursue a remedy outside of the courtroom. So when everything finished, I circled back with my civil rights lawyers and I told them that I wanted to file a complaint. I wanted to take the judge up on what he had suggested. And my civil rights lawyers, who had done a spectacular job for me, told me that it would be a waste of time and it would be a waste of money because nothing ever happens. So basically, the prosecutor got away with it. I want to add that 2 weeks before I emerged, suddenly he retired and ran to Florida. I guess we're supposed to believe that's a coincidence. So although he's not practicing law now, he still retains a law license and he could practice law at any point in time in the future. More importantly, nothing ever happened to him, certainly not criminally, not in the courtroom, not civilly, no censure, nothing. I was a victim of prosecutorial misconduct on the post-conviction level. First of all, I had requested further DNA testing twice from then Westchester District Attorney Jeanine Pirro, she rejected my efforts at getting further DNA testing, even though there was a prior Westchester County case, that of Terry Chalmers, in which she consented to exoneration based upon exculpatory DNA test results, stating publicly and defending that exoneration that the DNA test results made it clear that it was the right thing to do. So she knew, her and her office were well aware of DNA implications and its power, and yet she saw fit to deny me twice the testing. On the federal level, her office successfully got the court to dismiss my habeas corpus petition because I was 4 days late. The court clerk gave my lawyer the wrong information regarding filing procedure, and I had an actual innocence argument there based on the pretrial DNA, and they made that argument. Attorneys in that district attorney's office made arguments as spacious as saying that there was overwhelming evidence of guilt, which was laughable if it wasn't such a serious thing, considering the DNA. Ms. Pirro there's nothing to stop her from practicing law. Nothing ever happened to her. My organization.
She's a judge now, isn't she?
She's a judge now, yes.
A fake judge on TV.
A TV judge, yes, but we all, yeah, of course, but we understand what I'm trying to get at, though.
I got you.
In the case of two of the clients of my foundation that we were able to exonerate, Mr. William Lopez, who served 23 and a half years in prison, the federal judge in releasing him stated in his opinion that he referred to there being a deceitful prosecutor. I want to share the tragic news in terms of to bring home the human impact. My friend, my client, he died after a year and a half of freedom. His life basically stolen from him in large part based on prosecutorial misconduct. The other exoneration, that of Mr. William Hawley, which was up by Putnam County DA Tendy's consent, which I want to give him credit for doing. The prior DA, Putnam County DA Levy, offered 3 different times to release Mr. Hawley, but on condition he would have to plead guilty. Just the fact of him making that offer after a conviction had already occurred in an arson case that wasn't actually an arson showed that he knew there was something wrong with that conviction, and yet he insisted on that despicable condition, which Mr. Hawley refused to cave into, and ultimately he was exonerated. There's a lot of studies from the Innocence Project to the California Innocence Project to the Pew Center to remarks by Federal Judge Kozinski to studies from various newspapers and magazines of stellar credibility that there's a prevalence of prosecutorial misconduct. If the present system was enough, then there would not be a prevalence of prosecutorial misconduct. In all these different wrongful conviction cases, the common denominator is often prosecutorial misconduct. How many prosecutors in the studies that have been done of those cases have been disciplined afterwards? I want to also add that each one of these instances has cost New York State millions of dollars, but more importantly, it devastates the lives of the people affected. My family and the family of many of all the wrongfully convicted people, they were impacted as well, and there was a larger societal cost. The actual perpetrator in many of these cases strikes again. It happened in my case. The actual perpetrator killed the second victim 3.5 years later. There is no deterrent. I don't think that training, I'll wrap up in just a second. I don't think that training and, referencing various methods of reversing a wrongful conviction, that's not discipline. While certainly a big part of this, as I see it, my being a supporter of this, is a deterrent, some of it has to be punitive as well. when intentional, clear-cut misconduct happens, training doesn't quite cut it. I don't think you should consider exonerees to be survivors of crimes that were perpetrated against us. And I can't think of any other penal offense where an offender receiving training would be considered to constitute justice. And my last remark will be, and I thank you for having this hearing and entertaining myself and the other panelists, is while there has been a couple of good changes, I mean, the Putnam DA did do the exoneration, and the Bronx DA sitting to my right did have the Richard Rosario case overturned, which I give her a lot of credit for, 13 alibi witnesses. And I want to point out that the indictment is still not dismissed, by the way, even though there's the 13 alibi witnesses. But going past that, while we do have a couple of great changes in the promise of justice within both of those offices, we cannot say that means that there's a prevalence, that's the general attitude, that's pervasive. That's not, you can't overgeneralize that. And I think the biggest reason why you should enact this legislation and have a commission is that there is a denial within the profession of prosecutors that prosecutorial misconduct, that it happens. And so long as there's a denial, that's even more reason to note that it's not going to end if we keep the status quo as it is. Thank you very much.
Thank you. We have two more speakers. First of all, Robert Masters, the Assistant District Attorney of Queens County, and then we're going to have Emily. We left you last because you're going to be the star of this proceeding. I apologize, but somebody had to be last.
To start proceeding?
Go ahead. Star up.
Thank you for hearing me on such short notice. Tom Zugaby last night asked me to substitute for him.
Okay.
Really, the only one that I'm at all acquainted with among you is really you, Senator DeFrancisco. It seems over the last decade or so annually, this week in June, I come to talk to you, if not about this or about something else that's important in the criminal justice arena. And I have to say that although we may disagree about this particular topic, I've always found you to be a very fair and thoughtful voice in all of this area.
Continue, go ahead.
As I've been listening, I'm mindful of something that John Adams said, not well before he was president, and actually before there was even a United States. It was when he was defending those British soldiers in the Boston Massacre. And during his summation, he said repeatedly, facts are very stubborn things. And I think that while what we've heard here today is incredibly important, and we all have to continue to focus on this to try and make for better prosecutions and for a better criminal justice system, I think certain facts have to be looked at and have to be accepted. Only last year, the Office of Court Administration finished its commission's review of the attorney discipline in a report that was published in September. And in the report itself, it specifically concluded that there was no evidence of rampant prosecutorial misconduct. I think what we're working here, and I know that Judge Clark alluded to it, as did Scott McNamara earlier, I think we're in a difficulty of looking at definitions and labels. And prosecutorial misconduct is a very broad umbrella that covers an awful lot of sins. It does cover intentional, moral, awful misdeeds on the part of someone. But it also covers summation error, a mistake in cross-examination, and when the accusation is briefed, that's the label that's applied to it. When a case is reversed, that is the label that is applied to it, regardless of whether it was a mistake or something intentional and awful. The District Attorneys Association has taken this very seriously over the last few years. And Jed Painter from the Nassau County DA's office was the one who really led a remarkable review of all of the reported decisions in New York State between 2010 and 2015. And he had a committee of people reviewing all of these cases.
And pretty much he looked for every iteration of any discussion of the term prosecutorial misconduct. And although it was raised in that over 5-year period in 556 cases, what it turned out was that ultimately the courts only addressed it, only found it substantiated, and that didn't mean reversal, but substantiated in 54 cases total over a 5-year period across the state. And I have to tell you, that winds up being less than 10% of the times it's alleged. Among those 54 cases, almost 30 of them were summation error or errors in cross-examination of defendants. In our office, before myself and the Chief Assistant Jack Ryan testified before the Justice Task Force in January, we did an examination of the last 3.5 years of all of the reversals in the Second Department in our office. And what we found was that there were 10 times more reversals for judicial error than there were for prosecutorial misconduct, that just in particular topics that the reversals were on, for errors in conducting and handling by the court of jury notes, we had twice as many on just that topic alone reversals than we did of prosecutorial misconduct. And yesterday a decision came down from the Court of Appeals that would undermine all of those reversals. So that tells you the idea of how fluid the law is and how minor this topic is. There were as many reversals out of Queens County, which I know it's just one of the 62 counties in this state, but it is a county with a population that's larger than 13 states in the United States. There were as many convictions, there were as many reversals for ineffective assistance of counsel as there were for prosecutorial misconduct. And every one of the pros-mis reversals in my office was summation error. And that's one of the things that I think you should also realize. Summation error as a basis for reversal, which of course is the basis for applying that label of prosecutorial misconduct, is a very variable thing. It's strike zone dependent. And I think what we all know, for instance, in the recent trials of members who were formerly of this body, that things were said in summation that were reported in the news in those trials that I don't think there's a lawyer that practices in the state system realizes would have ever passed state muster. So those are things that I think that everyone should realize, that we, in New York State, we have one of the most, I think, diligent standards that's applied by the courts of reviewing when prosecutors are summing up. When I did appear in front of the Justice Task Force in January, I quoted from a summation in the famous Fatal Vision case where Dr. Jeffrey McDonald was convicted of the murder of his wife and 2 children. I'll spare you the portions and the riffs of that summation, but that case was reviewed by the Supreme Court of the United States twice. And when I read the portions of it, Judge Carmen Saparic, who is one of the chairs of that commission, came over to me afterwards and said, "You made that up, didn't you? That can't be so." I sent it to her. Nothing like that could ever transpire in the state of New York. We are very much restricted in that area. But that doesn't mean that we don't try and fix it. In an hour and a half from now, this is Wednesday, the Second Department will have its hand-down list. And one of my jobs is to examine what the Second Department says about our work. Last Wednesday, January 1st, was Judge Brown's 25th anniversary as the DA. We had a little celebration for him. Went back to my office afterwards and saw the hand-downs. There were 2 cases in which assistants were cited for prosecutorial misconduct, both for summation error. At 8 o'clock the next morning, Judge Brown called me to basically ask me, "We have to meet about this. I want to know what's in those summations. I want to know what's in those briefs." The reason I'm not in the meeting with him this morning is because I had to cancel it to come here today. We will go over those summations line by line with the district attorney of a county of 2.4 million people. The assistants will either be disciplined, they'll be corrected, they may even be sent back for retraining. Something will happen. We will make sure that that doesn't go on. And just a few other points that I think are of some significance. Mr. Deskovich was kind enough I believe it was in late 2009 or 2010, I don't know if you remember me. He was kind enough to come to the Best Practices Committee of the DA's Association here in Manhattan, in Manhattan. He spent hours with us, and I remember I questioned you about a number of real specifics about how his case evolved. And after he left, we spent the next 2 hours, a group of all the senior prosecutors in the state, discussing a number of things about how the misfortune that befell this man, how it occurred, where the system didn't work. We spent several meetings after that, once again discussing how did that happen? How did that occur? What can we do to stop it? By December of 2010, that's when the district attorney's office presented its guidelines on videotaping statements and interrogations. And all of the things that this man was subjected to have been sworn off against and are no longer the protocols and are against all the protocols that have been adopted by every police department in the state. Now, one thing that I will just say is we've talked about a case that occurred in my county. And it was a young man, he's not a young man, my contemporary, Claude Stewart. And Claude Stewart was a remarkable man who, frankly, was a terrible lawyer. He was a native of Belize. He immigrated here, joined the military, served in the Gulf, went to law school, and I have to say that we truly, he was a brave man, a wonderful parent, a good husband, and I have to say that our office fell in love with his story. And I think we overlooked again and again the fact that he was not a particularly good lawyer. And we advanced his career to handling cases that he was not capable of handling. And what we saw with Claude was what I think I have seen as a supervisor over the years. Most misconduct, and where assistants do things that are ethically dubious, it's not the really good ones. It's not the smart ones. It's not the talented ones. It's the ones who are struggling. And the ones who are struggling generally don't have the skills to deal with the evidentiary difficulties, to handle a particular case. And those are the ones that stop asking for advice because they're afraid when they ask questions, it reveals their lack of skills. It reveals their inability to handle themselves, and it may affect their careers. And I think that our office clearly learned in the wake of what happened with Claude that those are the assistants that we make sure get the most training. Those are the ones that we make sure wind up with the portfolios that are much less significant, where they're in a situation where they receive more guidance and can do the least damage and ultimately can be counseled through their career. That's something that we learned. So I hope that I've informed you of some of the things and the parameters that goes on in the day-to-day operation of the criminal justice system as far as we see it. I think that the discussion, Senator, that you've been bringing to the fore for, I guess it's 4 or 5 years now that I've been coming up here with it, although we continue to disagree about the end result, I think you should realize that it has been remarkably productive in that I don't know that 5 years ago the letter that Mr. Zugaby sent to the 3rd Department Character and Fitness Committee with regard to Ms. Rain would have ever happened. And I don't think that a number of the policing that we're doing among each other and watching each other and asking for the advice and trying to make sure that our house is in order would have occurred without you applying the pressure that you have. But I think that all the faults that everyone else has applied, the unintended consequences that have been mentioned in the legislation, I think still make it a policy that is a policy issue that could present far more problems than it'll solve. Thank you, Senator.
Thank you. And the final witness is Emily Dindile. Is that correct?
Hi, yes, that's right.
Policy Analyst, Innocent Project, and you're on.
Right, thanks for allowing me to testify. We actually did submit a letter for the on the record already. I just wanted to highlight a few points as well as address some of the arguments, and I'll try not to reiterate points that were already made. But, you know, the Innocence Project, what we do is work to exonerate innocent people nationally. using post-conviction DNA testing, as well as...
Can you move the mic closer to you?
Oh, sorry. Is
Okay.
this better?
Yeah, I think.
As well as identify the causes of wrongful convictions and work to remedy those to prevent such injustices in the future. You know, one of the causes is prosecutorial misconduct, and as we heard, it is a broad term. We use that to identify both intentional, violations of ethical rules, as well as mere error. And we heard that, you know, there are procedural processes in place, hopefully to deter this, but what those really do are they seek to provide remedies to the defendants whose rights have been violated. They're not really there to address discipline and sanctions and to deter that type of behavior. You know, the training that we heard about that's happening in the district attorney's offices is also great, and we commend it, and, you know, we want that to happen in conjunction with a committee that would, again, issue sanctions for the bad apples, which, as our prosecutor colleagues often argue, are rare, but they also tend to be serial offenders. So the commission would serve to sanction bad actors, but also to, you know, give centralized guidelines. Right now, each of the 4 departments charged with attorney discipline have their own sets of rules and procedures, being, you know, given out of 8 different offices. And if there were to be a chilling effect, you think that it would be under the current system where there's no notice to attorneys of what type of behavior is to be sanctioned, because there's so many different rules and procedures throughout the state. You know, behavior in one jurisdiction might be dealt with in a very different way than in another.
Have you familiarized yourself with the School for District Attorneys, NIFTY, to find out exactly what practices they teach young assistant district attorneys?
I have not, but I'm familiar enough with it, and I guess our point is that regardless of all these things that are in place and should stay in place, you know, it's clear from the exonerations that we've been working on that they're not effective. And addressing the causes of prosecutorial misconduct, you know, as well as other causes of wrongful convictions, is more than just an innocence issue, which would be enough on its own, but it's also a public safety issue. In the 341 DNA exonerations, we've been able to subsequently identify the actual perpetrator in 50% of those cases. Those perpetrators who remained at liberty while the innocent person spent an average of 14 years behind bars went on to commit more than 30 murders and more than 70 rapes. And that's just what we know of. You know, and criminalists estimate that probative DNA that can prove guilt or innocence is only available in well under 10% of all criminal cases. So our DNA exonerations represent the tip of the wrongful conviction iceberg, as well as the crimes that are committed by the true perpetrators while the innocent person was wrongfully incarcerated. So the Innocence Project did conduct an extensive review of the first 255 DNA exonerations and found that in 65 of those cases, allegations of prosecutorial misconduct were raised in either appeals or in the civil suits following exoneration. And in half of those cases, courts found either error or misconduct by prosecutors, but only found harmful error enough to overturn a conviction in 12. So you know, we feel that whether it's intentional misconduct or harmless error, it still contributes to the wrongful conviction and still needs to be addressed in some way. One of the reasons courts are reluctant to sanction or issue disciplinary action anyway is because of these other entities that technically have jurisdiction, but don't seem to be effectively addressing it. In New York, the disciplinary claims filed between 2012 and 2014 took an average of 856 days to resolve from beginning to end. Such delays allow prosecutors who do engage in misconduct in wrongful conviction cases, to avoid sanctions for years, and in some instances permit them to engage in additional misconduct while their cases are under review. It's especially troubling because, as I said before, there are usually just a few bad actors, and those bad actors do tend to be repeat offenders. So there should be more of an urgency to address their conduct. One of the great things about the legislation in front of you is that it necessarily requires the members to have some sort of criminal expertise, as opposed to the current system, which tasks civil lawyers with review of misconduct in criminal cases. And we think that having that expertise it better positions an independent commission to distinguish between intentional misconduct, which is in violation of the ethical rules and subject to sanction, as opposed to mere error, which would not be, and at least create some sort of a common guidelines for prosecutors to follow. Parenthetically, though not in part of this legislation in front of us, we do think it's worthy of public discussion to have a similar commission for ineffective assistance of counsel claims against defense attorneys. But all in all, we just think that the call for a centralized statewide agency charged with addressing attorney discipline in New York should be established. We support that to ensure a meaningful disciplinary process and hopefully prevent future wrongful convictions.
Thank you. I'm sure everyone who spoke today wants rebuttal, surrebuttal, and whatever comes after that. However, I think we get it based upon the testimony that was given here. However, are there any questions of any of the legislators here?
I guess I could ask a very generic question that hasn't really been answered by any of the speakers that know. If there have been, for example, any other models that have been considered in other states to monitor and discipline prosecutorial conduct. Because we don't really have anything to model from. I think that the sponsors of the bill, and I'm not a sponsor of the bill, I don't think, or I'm not on the bill, it's Mr. Perry's bill, but I believe that it's modeled after the Judicial Commission because we have no other models to go by in other states.
I think for the most part that is correct.
Could you just identify yourself?
Oh, yeah, this is Steve Downs.
Okay.
Yes, Steve.
And I think that is correct. It was modeled as close as possible to the Commission on Judicial Conduct. I am aware of other states, for example, Texas, I think, that has a commission to look into wrongful prosecutions. But I'm not sure whether it's temporary or not. I don't know how it functions, which isn't exactly the same thing. In other words, that is, I think, aimed more at trying to get people out of jail. I think Alaska may, for example, be experimenting with a commission. I've heard things about that. So there are other states that are sort of exploring, but I don't know of any other state that has the kind of commission that we're proposing here. I would say that.
That's what I thought.
Thank you, John. Thank you, Bob. I believe that...
Could you identify yourself? I don't know if we have nameplates here, so...
Yeah, they're clear.
There are nameplates there?
There are. I'm Assemblyman Nick Perry. The commission that we propose would operate or do a different work than what you just mentioned as pertaining to the commission you cited, because this commission's intent is to provide an opportunity for, or to be a mechanism through which complaints can be made and will be addressed to the extent that we can review these complaints and hold district attorneys and ADAs accountable for misconduct. And we did, as I said earlier, take care in naming the commission, Commission on Prosecutorial Conduct, because people will complain about conduct that is sometimes intentional, and also conduct that may appear, because of its outcome, to have been misconduct, but just happened as a matter of process, and where the accountability is necessary, but as far as discipline is concerned, it is something that would be subject to discretion in proportion to the damage that was done by the misconduct. I have questions for Mr. Schechter. Is Mr. Schechter?
There's an empty,
Schechter, there's an empty chair.
there's an empty chair there. In fact, nobody sat where you sat for some reason.
I'm going to
Yes,
take the question gladly and ask Senator DeFrancisco and the others for a few moments to comment on some of the statements that
You-
were made in the
Let's just
second
ask the
round.
question.
Right, Mr. Schechter, you spoke about the disciplinary committee. You-
Not the disciplinary committees?
Right. The committee, is this a formal, is this committee that you mentioned in your presentation, is this a formal committee?
Yes.
Like the Committee on Judicial, like the Commission on Judicial Conduct?
Well, it's part of the appellate division structure, these grievance committees.
Is
They're formal.
this the committee that looks at regular lawyers' practice?
When a lawyer makes a mistake, an error, whether it's ineffective assistance of counsel or an unethical conduct, this is the committee that you end up in front of.
This is the same committee that handles complaints against prosecutors?
Yes. That's correct. The difference seems to be, though, and the problem that we have with it, is that when you have ineffective assistance of counsel, for example, the attorney gets to go with his attorney before the committee to rebut or to explain what happened. But the public, the person who made the complaint, like Mr. Deskovic, he doesn't get to participate in that proceeding. He doesn't even know that proceeding is going on, which is why, in many instances, as we're quoted here this morning, you don't even get a response that there's anything going on.
Okay, so this currently is the only committee that has any authority or power to review a complaint that will be
Yes.
brought against a prosecutor.
That's correct.
And regarding this committee, is there any official statutory or other oversight on this committee that could have have this committee accountable in any way?
I don't know the formal answer to that. I think if you lose in the grievance committee process, you can appeal, and you can go into court, and it can be looked at by the court system itself. Such instances are few and far between, but that's pretty much it. The grievance committee is where you go.
And how is a member of that committee appointed?
Very interesting. A large number of the people who are on these committees seem to be appointed by the appellate division judges, sometimes by the chief administrative judge of the particular department. Now you might ask, what are the criteria for those appointments?
Is there any official criteria outlined?
None that I know of, except that you are a lawyer, you're well-known, you have a big firm, you have a big civil firm, you're known in the area. That basically is how it's
And is there
done.
any statute that says who makes these appointments?
Is there a statute?
Right. Is there any law, any
I-
authority that
I believe there is such an authority, but it
conveys
rests within
the-
the appellate division. They have the guidelines for who they appoint and how they do it.
So it's a rule of the appellate division?
Yes, it's totally
Okay.
ensconced within the judiciary. And that's one of the huge problems with these disciplinary committees. When I spoke to various people anecdotally, because no one will be quoted for the record,
And the rules of operation of these committees are set by any rules or regulations
well,
or statute
I
that we're
can't
aware of?
answer that. Nobody knows. It's a secret.
Now, doesn't the Court of Appeals also have the power to discipline attorneys?
The question was,
yeah.
after it gets out of the,
Okay.
after it gets out of the grievance committee, can it go higher? And I believe it can. It can go all the way through the court system up to the Court of Appeals, and you can be disciplined by them as well.
Okay.
Did I answer all your questions, Assemblyman Perry?
I think you did. I have a lot more, but we
Right.
don't have enough time today.
Excuse me. You're chomping at the bit. I've been in your seat before. The others are much calmer, but they're not, but they feel the same way about some of the things that you've said. So
Right.
why don't we get the questions, then we'll see how much time we have after that.
I have some questions for D.A. Scott McNamara. McNamara. You mentioned in your statement that checks and balances exists. Do you think that they're adequate based on the serious transgressions that have been brought to light regarding actions of district attorneys around the state on more occasions than we should have?
I think that the current system we have in place could work better. I don't think we need a new commission. I think what we need to do is we need to shore up what we currently do. I think that the grievance committee, there are certain things that have been said here, I would agree. I think the people that are put on it, there could be better people put on it, but I think the procedure we have in place right now, and I say this reluctantly, but I do believe it.
You believe
When I
it's
was
adequate?
young, I believed being a lawyer was an honorable job. And right now, that isn't the public's perception. And I think the grievance committee across the board has a lot to do with that, because we've lowered the standard. And there are so many things that go on that we're not here to talk about, but lawyers who are suffering from dementia, representing people on felony cases. There's a lot going on. We need to raise the bar at the grievance level. We need to make the grievance committees that we have, they need to have people on it that are competent. The Justice Task Force is looking at all these things. There needs to be a general standard that's the same across the state. There shouldn't be 4 standards. There should be 1 standard. There should be punishment. The punishment should be made public. The censures that go out now, the private censures, that should be reported. Okay, if it's private, then you don't report the prosecutor's name, but report it so that the public knows that people are getting their hands slapped. You know, for example, when I fire somebody, and I have fired people for doing things wrong, I can't put that in the paper. They're lawyers. They're going to turn around and sue me. But there are so many things that go on that are unreported. So I don't believe we need a new system. I believe the system we have could work better. And I think that's where we should put our attention, because there's already a system in place. And, but there is no reporting. And I'll tell you something. I had to file a grievance against one of my assistants, and something that somebody else said is very true. I never got notification what happened. I got notification from that prosecutor because I have a rule in my office: if a grievance is filed against you, you must tell me, and if I find out that happened, you didn't tell me, you lose your job. So I found out that way. The grievance committee didn't send me a letter back, and I was the complainant. That needs to be fixed. There's many things in the current system that we could fix that would make the way it works, would not only make the system a lot better, but it would also respond to the concerns that I think really what's going on is that the public doesn't know. And because the public doesn't know, they presume it doesn't happen. If they knew what was going on and there was public accountability, I think everyone would feel better.
So you seem to be saying that it's not adequate.
I said, I think it's adequate, but it could be much better. That's what I'm saying.
You made a pretty terrific argument there that it's not adequate, District Attorney, because you cited
No,
a
I was
lot-
being honest with you.
I appreciate that, but you cited a lot of reasons why it needs fixing, and that's why we have proposed this fix, which would take care of most of those issues that you raised, that I'm sure as a district attorney, there are colleagues who would agree with you that your perception of what's wrong with the system is real. And that's what we think here too. You commented on what is, I believe, the feelings among the district attorney who might be in opposition to this bill. You stated that we have rights, and I just want to add, in response to that, that this proposal, this law, if it should be, this bill, if it should be enacted into law, will not transgress on or take away any rights currently enjoyed by current district attorneys. There's no provision in our legislation that would impinge on the rights that you currently have. And we can understand that there will be opposition, but we stand quite ready to work with district attorneys who acknowledge that we have an imperfect system and that this part of the system is so important. In this, district attorneys have so much power over life, liberty, that we do need to have a system of checks and balances that will serve the purpose of renewing trust in our criminal justice system, because that's a part of the problem. And no part of our criminal justice system has a right to or should be left to police itself, especially in matters of misconduct.
But we don't police ourselves right now, sir. We are policed by
to a great
grievance
extent you
committee.
do. To a great extent you do, because where complaints are not made, and part of the reason complaints don't come about that can be handled is because the whole process through which complaints can be made, it's not clear, and this commission would provide that kind of mechanism.
Can I just ask, after hearing your testimony, sir, are you a lawyer?
Emily, me?
Yes.
Yes.
Good. I just wanted to ask, how do you currently handle incidents of perceived prosecutorial misconduct?
Of perceived
How do you handle the
Well,
incidents that occur, or you know, how do you deal with them so that we can see how the system works? Because the system isn't broke, then we shouldn't fix it. But we want to find out from the defense bar, I think, that are here.
Well, then
I
I
just wanted to hear
might
from
not
you
be the
about it.
best person to speak because I'm not a staff attorney at the
Okay.
Innocence Project. I am in the policy
So
department.
maybe one of the
from
others can
policy-
address that issue.
As I understand the question, if there's perceived prosecutorial misconduct, how is it handled? In different places in the state of New York, different approaches are taken. Some are informal. For example, in upstate New York, where the prosecutor's offices are small and the number of attorneys practicing before them, everyone knows each other, when there's prosecutorial misconduct, the attorneys, or maybe the head of the local bar association, goes to see the district attorney. And in upstate New York, you can get in to see a district attorney. It's Fortunately, that's a good thing. And so there's an attempt at rapprochement, if not an attempt to solve the problem. Sometimes the district attorney's office is very hostile, and that will not work. So if you can't get the district attorney to meet and consider the problem and change it, then the next step is, and some attorneys do this and some don't, is to write a letter. When you write a letter to the district attorney's office, you are saying to the district attorney, okay, we're on record now. No more oral conversations. I'm telling you this prosecutor is engaging in misconduct. Then you wait to see what happens. Some district attorneys will have their assistants meet with you, and then sometimes what you find is that that particular prosecutor, A, is transferred to a different bureau, 2, taken off what they're doing, 3, quote, leaves the office, unquote, and goes elsewhere. Or the prosecutor continues in their current position, and you find out at the first of the year they've been promoted to a section head position. The next thing you can do after that is to go file with the grievance committee. To do that, you have to first consult your client and understand the client's wishes have to be taken into consideration, that the client comes first. You then file with the grievance committee the nature of your objection. When the New York State Association of Criminal Defense Lawyers filed its complaint against Mr. Taylor of Ontario County, it was an extensive brief that listed specifically the court cases, what he had done, and had exhibits attached. Then you wait. And the answer to that is you may wait forever. We still have no response, almost 2 years later, what is going on with Mr. Taylor. We know he's still working. He's still in the DA's office. He's still handling cases. That's the short answer to the question.
Yes.
Just that the reason that our policy department is advocating for commissions like this one is because the current process is insufficient, and when we come across misconduct, it's because of our post-conviction cases, and we usually find it in discovery, post-conviction, and then there are not sufficient ways to deal with that. We have one case where a prosecutor was subjected to criminal charges, but a more efficient way, we think, would be an ethical commission to review those issues.
Can I add
Yes.
something? I would,
Yes. Yes,
Assemblyman,
Judge.
Perry, I understand your questions and your need to have a clarification of whether or not the current system works. I would just add that the Supreme Court Appellate Division, all of the departments are the ones that promulgate the rules for attorney disciplinary matters, and that as of July 1st, coming up this year, that those rules have been changed and modified, and that the court system has decided to go to a more uniform system of all 4 departments that do have these either disciplinary grievance or committees of professional standards. Hello? I'm sorry. I understand your need for clarification of the current system and as far as whether or not it works, and you're asking if there are any rules. But I can tell you that as of January 1st of this year, the Supreme Court Appellate Division, all departments, there are 4 departments that have these either disciplinary grievance or committee on professional standards. They're called different things in each department. That the rules for attorney disciplinary matters have been modified and or changed, and are going to take effect as of July 1st of this year. And that the court system has determined, after much discussion and study, that there needs to be more uniformity between all 4 of the departments. And they worked very hard on that, and as of July 1st, those new rules are coming out. I would suggest, and I could forward to you, just like I'm going to forward to you some of the cases that I cited, this section on Part 1240, the rules for attorney disciplinary matters, so you can see exactly what the rules are and what jurisdiction and authority they work under.
Assemblyman Perry, the answer is not uniform rules. You can make those rules as uniform as you want, and it's not going to change the issue of prosecutorial misconduct. The same rules that will come out in July preserve the system. It allows the DA, upon a complaint by a lawyer or a citizen, to go into a closed-door proceeding with counsel, not be challenged, tell a story to the grievance committee that goes unchallenged except for questions largely by people who are not well-versed in the criminal law.
Well, the same thing happens under the Judicial Commission.
That is how prosecutorial conduct continues.
Well, it's Judicial Commission.
Assistance of counsel, are we going to expand this commission to include ineffective assistance of counsel?
Of defense attorneys?
Excuse me a minute. Excuse me.
There are 3 players in the criminal justice
Yes,
system.
and one player happens to be the judges, and there's a Judicial Conduct Commission.
Yeah, but
the other,
Senator,
excuse me,
but Senator,
excuse me, the other player is the defendant. The other player is the defense counsel.
Yes.
Okay. If there's inefficient assistance of counsel, they can be disciplined under the procedures that you think are so wonderful, the grievance committee.
But there's privacy there too. Are you going to create a special section to allow for that to occur?
And also the Judicial Commission also is private. That is not totally public. I was a judge for 16 years. They have judges that complaints have been filed against them and they never knew about it.
The procedure that this...
It's the same thing.
That's my point. That's why we use the Judicial Conduct Commission as the exact duplicate of this bill. So the concerns about, what you're concerned about, the judges were concerned about in the 1970s when this thing first started out. And no one seems to complain about it right now. I haven't heard any complaints about Judicial Conduct Commission, like we hear with everyone else. Before we get into a battle here, it's been very civil up to this point in time. Before we get into a free-for-all, I just want to recognize Senator Bonasek. He wanted to make a comment, Senator Boyle, and then we'll see where we are at that point.
Yeah, it's good.
First of all, thank you all for being here. I apologize that I didn't hear the whole hearing.
Got it.
Thank you, Phil. I apologize, we didn't hear the whole hearing, but we had multiple things going on. There's a lot of stress today in the whole judicial system. The economy, breakdowns in family, money issues, and it all is in your lap. We feel the stress, you feel the stress. And so I appreciate that. The anxiety is harder. Everybody's life is harder. I'm a former assistant DA. To me, the assistant DAs, honorable profession, the good guys. And I'm thinking, if I vote for this legislation, am I giving defendants another tool in their toolbox to delay justice, to go after the good guys? That's the question, I think, in my mind. And I've spoken to another senator who was a prosecutor also. And then I see trends happening nationally and at the state level. Nationally, our Justice Department does things, and I'm not talking only about New York, that targets political enemies. And that's disturbing to me because they're the good guys. I see DAs that have blind ambition, that want to go up a ladder. That scares me. And it's not the dumb ones, it's the very smart ones that we have to worry about. And I don't say, I think the lion's share of the DAs do a great job. I do. And that very small segment that intentionally commits prosecutorial misconduct with malice, oh, I would love to put them on the side and nail them.
So would
because
we.
it makes it hard for everybody in this room.
So would we.
And I don't know how we get at that without hurting the good guys, okay? I just want to say, I give Senator DeFrancisco a lot of courage for him to go here, because this is a sledgehammer. It's a sledgehammer against the district attorneys, and maybe they don't, I think the lion's share of them shouldn't get hit in the head with it. But at the same time, I do believe there is a trend that's getting more dangerous, because I think the most dangerous person in the world is a DA that can indict a ham sandwich. It was always that way. Always that way. And how do we get at them? My last point. You brought in another dimension as a result of this discussion. I think it behooves the DAs and the defense attorneys to get together and come up with a plan that makes the system more efficiently, with a timeline, and get it to me. I'm not talking about prosecutor misconduct right now. I'm talking about delays, not having a word at the grievance hearing, not hearing. That's not all right. That's wrong. So whatever we can do in our power to correct that. I'm looking to get at the bad apples, and I think they're a minority, but they're existing, and I think they're growing because of social media, and all I see DAs now out more than politicians taking pictures at events that have nothing to do with judicial proceedings. So it's a different, for some of them, they're different animals. Not the guy that's devoted his life, loves the business, tries to be fair, and always do the right thing. I don't worry about those people. I worry about the new breed, the blind ambition breed. And they're out there, and I think they're growing. Okay? So I'm going to leave it at that. I'm just talking of observations and my instincts. And, you know, we'll deliberate very carefully on this stuff, because we don't want to hurt the good guys, but we sure as heck want to hit the bad guys with the sledgehammer.
Thank you, Chairman. I unfortunately have to run to another hearing, but I did want to thank Senator DeFrancisco and Chairman Lenthal and my colleagues, all the witnesses, and particularly the exonerees for testifying. I think some of the arguments that were made today were powerful, but what struck me perhaps was the gentleman from Queens, Mr. Masters. I think you made an argument to me that actually was in favor of a commission, because you talked about this case. I know, Mr. Stewart, I guess, was the case, and you said, well, we loved his story, he was a good guy, and that's the reason, because the internal politics of your office said, let him stay. Maybe, I'm sure he wasn't doing it I don't think he was doing it on purpose, but the fact that you guys liked him. So to have an outside independent body look at situations like that is a strong argument to me. In terms of the need, we talked about in the 70s, the Judicial Conduct Commission came about as part of cases and popular. Well, I can tell you right now, in popular culture and the cases in this country, there's a movement for prosecutorial misconduct commission. I mean, whether it's communities of color, obviously they do not trust the prosecution. Making a murderer didn't happen in New York, but everybody's seen it here, I assume. If you haven't, I suggest you do. And the quote by the defense attorney in that documentary. He did not, in his long defense attorney career, he said, prosecutors do not frame innocent people generally. They find people they think are guilty, and then they do bad things. And I think a lot of American culture feels that way as well. So because of those things, and because of what's going on in Suffolk County and St. Lawrence and other areas, I think the time has come for that. But I thank you very much for the information. It was great, and we look forward to working with you as we move forward with this possible legislation.
First of all, I'm going to disagree with my colleague, John Bonasek. This bill is not, nor was it ever intended to be a sledgehammer against prosecutors. Never. That has never occurred to me. The fact of the matter is, in the military, I prosecuted cases for about a year and then was transferred out, did defense work. I was in the prosecutor's office in Onondaga County when Bill Fitzpatrick was a clerk, who's revered in prosecutorial circles. And then I did defense work. I tried 2 murder cases for defense. I know the system, and I know what happens and what doesn't happen. I also know that prosecutors have the most power of anybody. Anybody. A mere accusation, as we're hearing from the Rain case in St. Lawrence, it's just one of many, that a mere accusation of misconduct and a potential criminal investigation ruins the person, okay? So what do you do about it? Do you just continue on with what's going on now? Well, there's no remedy. I don't care who says the grievance committee. It's nonsense. There's no prosecutor that I know of that any consequences whatsoever has ever happened, and especially when you hear the victims, what's happened to them on the other side. So that I want to make clear. Number two, so what's the remedy? We're not going to change all the laws and change human behavior. There's going to be good and bad legislators, good and bad prosecutors, good and bad defense counsels. The fact of the matter is you got to find a model that has been a reasonable model that's fair for both sides. And I was around in the 70s when this Judicial Commission came up. You would think the world was going to end and judges were going to be brought before a public display and humiliated. The fact of the matter is what's happened over time is there are judges who are made complaints against that are exonerated and shown that in the initial process, as Mr. Tembekshi had said, the initial process, just they get rid of the file because they know it's ridiculous. Or it goes on, and I really believe that the most serious situations are dealt with, unlike the grievance committee. So, rather than a sledgehammer, this is the model that Assemblyman Perry and I came up with that we thought would be fair, because we've got something that showed it was fair in the past, and it's working quite well now. Now, many people here hate it. Others think it's the best thing that's ever happened. It's probably somewhere in the middle. Now, procedurally, where is it going to go? We've got 5 days after today, or 4 days after today, for the bill to get to the floor. Whether it does or not, I don't know. It got to the floor in both houses last year. It never came up for a vote. We're giving our opinion and our solution. We still need the votes in order to make it happen. But I'm going to try to convince people that this is a good remedy where none exists right now to try to make it happen. And if you disagree with me, God bless you. But the fact of the matter is that's where I'm going. And you obviously can lobby other legislators and see where they stand. But that's basically where I stand. And we'll see what develops between now and the end of session. Anything else?
Yes.
Okay.
Since we're doing some soul searching, let me do some of my own. First of all, I started out my working life as a prosecutor, as an assistant DA in Brooklyn, and I loved that job. It was one of the best jobs I ever had. Unfortunately, some other calling got me here. Now we're not only contemplating this bill, but we're contemplating doing some measures for public officials like myself, like the senators and the assemblymen on this panel, because of the bad things that some folks have done in the legislature. We don't like doing it. We don't like being tarred with the same brush as our brothers and sisters who have gone before us and broken the law. But unfortunately, we have to deal with it. So it's not as though we're not considering action for ourselves. We're probably not going to be able to leave Albany this year without passing some meaningful legislation on ethics reform of some type or another. So I say that only to reinforce the fact that I'm not a sponsor of this bill. But I think the model that, well, I'm not the major sponsor of the bill, let me just say that. My name is on the bill because I believe in it, obviously, or I wouldn't be here today. Because I think that the time is right for us to take some action, just like Senator DeFrancisco said, that I believe is fair and reasonable, so that there can be some, I would have liked to ask Mr. Tebekian some more questions about that so that we could get to the heart of the matter, and that is how the commission would operate and what shortcomings he would see in the process for DAs or assistant DAs who come before him, but that's for another hearing, because I doubt whether or not we'll have time to do this bill. I mean, Mr. DeFrancisco and Mr. Perry are optimistic, but we have a lot to get done, and I'm sure that there's enough political will against the bill that might prevail, and that's unfortunate. But I dare say we will get to it. If it's not this year, we will get to it next year, I hope. And we want to, during that time, we want to dialogue with you so that we can, if we come to a resolution on this, we can work together in developing it, just like we developed the Commission on Judicial Conduct.
Well, you're not speaking up because you're not a member of the group that's been asked to speak. Go ahead.
Mr. Perry.
Thank you, Senator. Thank you. The power of the district attorney is awesome. I don't know if you can properly measure how awesome that is. And any one of us that, especially in the community that I represent, African American community, where young men and young women face a prosecutor every day, thousands and thousands of times, and they have to make decisions and think about offers that are put to them by prosecutors, sometimes fair, a lot of times unfair, sometimes with reason, sometimes absolutely no reason at all that would prevail in a trial. Prosecutors are aware of this, but they make the offers anyway to reduce their caliber of cases. And these youngsters face a system that is just rigged against them. I go through that with my own family, and I know, as a matter of fact, that this awesome power has to be checked something. There has to be some accountability, and it's really important to me. And I happen to have the privilege of being the chair of the court, and I do.
Good. Yeah.
I happen to be the chair of the Black, Puerto Rican, Hispanic, and Asian Legislative Caucus. This bill is a priority on this. We're doing everything to get it passed in the Assembly this year, before we leave. I'm committed to that. I'm also very committed to working with the district attorneys. I've done work with district attorneys over my tenure, and I've worked with district attorneys in all the boroughs in the city of New York. District Attorney Brown in Queens does a fine job. We have outstanding work by our district attorney. So this is not a sledgehammer against district attorneys. None of us are biased or intend to do anything to harm the office of the district attorney. But we are concerned with the trust in the criminal justice system from the people that we represent. And that's our motivation. That's why we're pushing this. And it will help the office of the district attorneys if there is trust in the system, so that people will have confidence in the work that you all do as the office that represents the people in all of these cases. Thank you.
And thank you all for coming. I know everyone has something else they want to say. If you want to say it, if you want to write to Assemblyman Perry and myself, so we'll have that information. I'd be more than happy to accept it. But we got to stop now because we have to go to conference, then session. Thank you again.
Thank you.
Thank you.